Lords, one copy of the written submissions, Lord, I'm told could not come here, my lords. That doesn't matter, my lord. It is getting printed. I would be able to place it for a lot of perusal in 15 minutes, my lord. We just came to know 5 minutes back. Otherwise, I would have kept, my lord. In the meanwhile, we have the digital copy, my lord.
Continue and we will note down the point.
No, kindly, my lord, give me only 15 minutes.
Justice Narasimha and Justice Vikramnath, they don't require physical copies.
Have it in the shop. मेरा पास भी होगा आपके पास भी होगा
Yes.
Article 111 now.
111, 155.
55.
I have completed 111.
Yes, complete.
I have completed 74. My lords would find it at page 128.
Yes.
Lord, this is appointment of the governor, and this would, I'm sorry, but this would have tremendous bearing for your lordship's consideration, because, Lord, the concept which is going on, that the
ये रखिए
what is the significance and sanctity attached to the office of the governor? Lord, that we come to know from the Constituent Assembly debates. Lord, it's not, my lord, an asylum for retired politicians, as, my lord, we understand. It has its own sanctity. And, my lord, the framers of the Constitution have debated on it, that why we need governor, why we need governors with the powers which we are going to confer upon it, and in the federalism which we have adopted, as against, my lord, the absolute federalism in United States, where each state or province has its own constitution, has its own Supreme Court, has its own, my lord, way of governance. We have not adopted that.
Even dual citizenship.
The dual citizenship. So, my lord, they have examined that center will have to play a role in the governance of the provinces, which is now states, and that is how, my lord, the position of governor is conceived. Lord, please have a look at page 128. Lord, section 46 is the peri materia provision, or, my lord, if I may say, the precursor to the present 155, where the governors were appointed. Lord, page 128 bottom, Government of Bengal, Madras and Bombay. The presidencies of Fort William in Bengal, Fort St. George and Bombay are subject to the provisions of this act, governed by the governors in council of those presidencies respectively, and the two former presidencies are in this act referred to as the presidencies of Bengal and Madras. Then, my lord, comes 35 Act. Lord, initially the idea was that the governor should also be an elected person, so that he also wields the same democratic sanctity, and which is rejected by the framers of the Constitution. I'll show that, my lord. Section 48, Lord, 1935 Act, again, my lord, the colonial era act. The governor of a province is appointed by His Majesty by a commission under the Royal Sign Manual. The provisions of the third schedule to, my lord, not relevant. Now, my lord, draft constitution, my lord, which was prepared by Mr. Rao, the governor of a province shall be elected by direct vote of all persons who have the right to vote at a general election for the legislative assembly of the province. My lord, Dr. Rao introduced the concept of governor being an elected person. Then, my lord, the drafting committee chaired by Dr. Ambedkar ji, my lord, made this. Again, my lord, provided for election. the governor of a state shall be elected by direct vote of all persons who have the right to vote at a general election for the legislative assembly in the state. So his election would be confined to that particular state. Then, my lord, the drafting committee gives a second option for consideration. An alternative is given. That is, my lord, this. The governor of the state shall be appointed by the president by warrant under his hand and seal from a panel of 4 candidates to be elected by the members of legislative assembly of the state, or where there is a legislative council in the state, by all the members of legislative assembly and of the legislative council of the state assembled at a joint meeting in accordance with the system of proportionate representation by means of single transferable vote, and the voting at such election shall be by secret ballot. So they were visionaries. They gave 2 options, appointment or election. Appointment, my lord, again by indirect way of election only. Now, my lord, please see the debate. My lord, at page 130 it starts. The Honorable President says, as regards this, honorable members will see that there are 2 alternatives suggested by the drafting committee. The amendments are referring to either the one or the other alternative. So I think the best way is to take an amendment in favor of one of the alternatives, and if then is accepted, then all other amendments relating to the alternative drop automatically. We take 2006, and this is, and if this is carried, then we go to the second. 2006 is the number of that amendment.
Number of them.
Yes. Then, my lord, Ghanshyam Singh Gupta. Sir, I suggest this. The amendments, of course, may be taken, but first we might form our opinion as to whether we want the first or second alternative, so that if we want the first alternative, then the amendment it would come, my lord, in kindly bear with. Then, my lord, Sri Brajeshwar Prasad, my lord, this is important. For, my lord, he suggests that for Article 131, the following be substituted. Governor of a state shall be appointed by the president by warrant under his hand and seal. He said no election, whether as per alternative 1 or alternative 2. And the reason or the justification, my lord, he places before the assembly. The great merit of this amendment, which stands in the name of the 5 or 6 members of this house, is that it lays down a simpler procedure than the prescribed either in the article or in the alternative suggested by the drafting committee. I feel, sir, that in the interest of all India unity and with a view to encouraging centripetal tendencies, my lord, that is a tendency, my lord, to my lord,
Stronger.
unification,
Stronger center.
the strong cohesion, my lord, if I have used policies, tendencies, it is necessary that the authority of the government of India should be maintained intact over the provinces. To say that the president may nominate from a panel of names really means restricting the choice of president. It gives power into the hands of the legislature. It is necessary, sir, that the president should be free from the influence of the legislator. I feel that the governor may be one from the province or from another province. Personally, I feel that the man from a province should not be appointed in the same province because it gives encouragement for vociferous tendencies. So, my lord, that tendencies, my lord, internal fixed, etc., etc. So I say that choice of the president should be unrestricted and unfettered. Sir, I have nothing more to add. This is a simple proposition and I commend it for acceptance of the House. Then Alladi Krishna Swami Iyer. Sir, in view of the decision that was reached some 2 years ago and in view of the fact that I feel convinced that only right course, taking all the circumstances into consideration, is to accept the amendment of Mr. Brajeshwar Prasad. I should like to say a few words in support of the amendment. In the consideration of this question, the main points to be remembered are that this assembly has accepted the introduction of responsible government in different states, that the governor is merely a constitutional head of the province, and the real executive power had been vested in ministry responsible to the lower house in the different states. No dispute or difficulty. The real power vests in the elected people who are elected by the legislators, by the my lord, people of that state as legislators. Uh, the question for consideration before this House is whether, under these circumstances, there is any point in going through an expensive and elaborate machinery of election based upon universal suffrage. After giving my best consideration to the various proposals put forward, one, of choice of governor on the basis of universal suffrage, two, of election of the governor by a majority of lower house or of both houses, whether on the principle of proportionate representation or otherwise. Third, of a selection of a panel by the lower house in the state from which the choice, lower house is Lok Sabha, not legislative council, but legislative assembly, wherever there is any. Choice is to be made by the president of the union, or four, if appointment by the president in consultation with the cabinet. I feel that the wisest course to adopt is the last one. If the governor is properly functioning as the constitutional head, the expenses involved in going through the process of election is out of all proportion to the powers vested in the governor under the constitution. There is also the danger of governor who has been elected by the people at large getting into a clash with the premier. Well, that is the chief minister of the state.
Two power centers.
Yes, two power centers, my lord. Uh, and the cabinet responsible to the legislature, which itself has been elected on the basis of universal suffrage. Again, the election itself, under modern conditions, will have to be fought out on a party ticket. The fact is that even at or during the elections, the party will have to rally round a leader who will presumably be the future premier, the chief minister of the province. Is the rallying to be round the governor's name or premier's name? In the normal working of the government, also there is a danger of a clash between minister and the governor, whereas the whole basis of the constitutional structure we are erecting depends upon the harmony between the legislature and the executive, and between the executive and the formal head of the government. There is no correspondence between the governor of a state in United States of America and governor under our constitution. In the case of a governor of a state under United States, the real and substantial executive power is vested in the governor. There is a distinct separation between the executive and the legislature in the United States. A proper analogy has to be sought for the Constitution of Canada, where a responsible governor obtains. In Canada, the lieutenant governor of each province is appointed by the governor general, that is, by the governor general on the advice of the cabinet, similar like India, my lords. There are many features of resemblance and similarity between the Canadian Constitution and our Constitution, which, by some critics, has been considered to be quasi-federal. The system, in the main, we have accepted is the principle of responsible government obtaining in the dominions or in different parts of the Commonwealth. Nowhere does the system of election of governor exist where the institution of responsible government is the main feature of the Constitution. In the normal working of the Constitution, I have no doubt that convention will grow up of the government of India consulting the provincial cabinet in the election of the governor. If the choice is left to the president and his cabinet, the president may, in conceivable circumstances, with due regard to the conditions of the province, choose a person of undoubted ability and position in public life who at the same time has not been mixed up in the provincial party struggle or factions, is not a part of the local state politics. Today, it appears to be very obvious to us, but kindly visualize the vision of the framers of the Constitution.
But then whether have we lived up to the vision?
Yes, madam.
If in the first paragraph,
Yes, madam.
they said that there would be a harmony between the governor
Yes, madam.
and the
No, I'm slightly on a different.
and the ministry.
Yes, madam.
And the second part is, in the normal working of the constitution, a convention would be developed that the provincial government would be consulted while appointing
I
the
am on a
governors.
different point. But deviations or my lord, some exceptional situations, my lord, may not guide your lordships in interpreting the
So
constitution.
you are relying on this.
The limited
No,
point,
you
my lord,
are-
there is something further.
No,
There is
you are
something.
entitled to rely on the debates in the Constitution Assembly, no doubt. But then whether the expectations that were
No, my lord, kindly,
Express.
I stopped at a wrong stage maybe, but the point I was.
your or rather we stopped you at the wrong,
No,
wrong stage.
No, my lord, the real point, my lord, I was trying to make is divorce the facts. That look at the vision of those, my lord, who were discussing this in 1947. And they could visualize these are the problems which will arise. If a person is to be elected or
There
if
are going to be two power centers.
two power centers.
One the chief minister elected by the majority of the legislators and the governor who is directly elected.
Directly elected.
And then the system that we have accepted is the government responsible to the legislature.
Correct. Government, the cabinet is answerable and responsible to the cabinet. my lords. That
No, cabinet is responsible to the
to the legislature. The cabinet is answerable to and accountable to the legislature. Well, thereafter, the bold part. my lord, the central fact to be remembered is that the governor is to be constitutional head, a sagacious counselor, and advisor to the ministry. The governor chosen by the government of India, presumably with the consent of the provincial government, is likely to discharge his functions better than one who is elected on a political party ticket by province as a whole based on universal suffrage. Now, my lord, Pandit Jawaharlal Nehru, Lord, says this, my lord. Sir, this debate has already elicited so many speeches that probably every conceivable argument for and against this proposal has been placed before this court. I do not know what I can add to it. My lord, kindly come to, my lord, the bold part. There was the Union Powers Committee, my lord, headed by Nehruji. There was the Provincial Model Constitution Committee, headed by my lord Sardar Patel, of which my colleague, the Deputy Prime Minister, was the chairman. After all these considerations and discussions, those committees felt that a certain change was desirable. Thus, even those like Sardar Patel, who themselves put this forward in this house, the other view, feel that the change would be desirable. This was the flexibility of Sardar Patel, my lord. He chaired the provincial committee, took a particular view, and thereafter takes the holistic view and say that some change is desirable. Now, the reasons for this have been stated before the House, and I need not go into them, except to say that I myself originally was not very definite, if I may say so, in my mind as to which would be the preferable course. I preferred something, but not to the extent of considering it as absolutely necessary. But the more I thought about it, the more I conferred with others and discussed with them, the more I felt that from almost every point of view, this proposal that is moved of a nominated governor in the present context of the Constitution was not only desirable from practical point of view, but from democratic point of view, too, it was desirable and worthwhile. My lord, now I can skip that, my lord, and kindly come to the bold part. My lord, I have, this is the way, my lord, I generally make it bold so that the relevant part is before your lordships, but we don't consume your lordships' time in reading them. And I must tell your lordships, my lord, I have selected passages from the Constituent Assembly debates which are relevant according to me for deciding this issue by your lordships. There are other debates also on these subjects. Entire debate is placed in volume 4. If your lordships would like to, 4.2, my lord, if your lordships would like to go through it. But these are the relevant debates, my lord, from the standpoint of the issues which your lordships are advising us, my lord. But on the whole, it probably would be desirable to have people from outside, eminent people, sometimes people who have not taken too great a part in politics. Politicians would probably like a more active domain for, but there may be an eminent educationist or persons eminent in other walks of life who would naturally, while cooperating fully with the government and carrying out the policy of the government, at any rate, helping in every way so that the policy might be carried out, he would themselves represent before the public someone slightly above the party and thereby in fact help that government more than if he was considered as a part of the party machine. I do submit that there is really a more democratic procedure than the other procedure, in the sense that the latter would not make the democratic machine work smoothly. Then, Dr. Ambedkar, my lords. Yes. My lord, the first part of the Dr. Ambedkar ji is only, my lord, the description or a paraphrasing of what has happened. The second part would be relevant, my lord. Well, well, that power, your lordship gets, my lord. Well, that power an elected or a nominated governor will have, if he happens to call the wrong person to form a ministry, he will soon find to his cost that he has made a wrong choice. That is not a thing that could be avoided by having an elected governor. Such a governor may have a friend of his choice whom he can call in to form the ministry, and that issue can be settled by the House itself by a motion of no confidence or confidence. But that is not the aspect of the question which is material. The aspect of the question which is material is the governor going to have any power of interference in the working of a ministry which is composed of a majority in local legislature? If that governor has no power of interference in the internal administration of a ministry which has a majority, then it seems to me that the question whether he is nominated or elected is wholly immaterial. That is the way I look at it. And I want to tell the House that in coming to their decision, they should not bother them more or less academic question whether governor has to be nominated or to be elected. They should bear in mind this question: what are the powers which the governor is going to be endowed? That matter, I submit, is not before us today. We shall take it up at a later stage when we come to question of Article 175 and 188. Please note there, my lord, in your lordship's note, 175 is the draft article, which is Article 200 today. And 188 is emergency powers, my lord, which are not, which we are not.
Not concerned at this stage.
No, not concerned. And probably by amendment or the addition of some other clauses which would give him powers. The House should be careful and watchful of these new sections that will be placed before them at a later stage. But today it seems to me, if the Constitution remains in principle the same as we intend that it should be, the governor should be a purely constitutional governor with not power of interference in the administration of the province. Then it seems to me quite immaterial whether he is nominated or elected. Now, my lord, what is accepted is 131 draft article. The governor of the state shall be appointed by the president by warrant under his hand and seal. My lord, both the alternatives were given up,
And
and
third,
Vijeshwar Prasad's amendment that he should be appointed by the president, nothing more, nothing less, should be there. So far as his powers are concerned, we will consider when we consider present article 200, and I'll be able to show that this wish, desire, and Lord, what was in mind of the constitutional framers did reflect in Article 200, that he would have only those powers which are conferred and nothing more, maintaining supremacy of the elected wing. My lord, I'll come to that, my lord. Please, now, my lord, come to next page, Article 163. Page 134, Article 163. My lord, it is in pink color.
Yes.
Your lordship gets one. My lord, this green color final draft of the Constitution is, my lord, same, which I have read, my lord, therefore I am not reading it. The color is, my lord, there is some legend, my lord, green is the final thing, etc. At my age, my lord, I can be colorful only on paper.
we agree to disagree.
He's not telling you the entire truth.
No, but that's what I said. We agree to disagree.
Yes. Lord, 163. Lord, what was 1919 Act? Lord, I have quoted, but what is bold is, my lord, relevant for the present purpose. For completeness, I have quoted this whole. 3. In relation to transferred subjects. My lord, when the assembly talks about transferred subjects, it means subjects allotted to state, list 2, 7 schedule list 2, present. The entries may have changed, but transferred subject would mean the state list, where legislature has the power or competence to legislate. In relation to transferred subjects, the governor shall be guided by the advice of his ministers unless he sees sufficient cause to dissent from their opinion, in which case he may require action to be taken otherwise than in accordance with that advice, provided that rules may be made under the principal act or the temporary administration of a transferred subject where, in case of emergency, owing to a vacancy, there is no minister in charge of the subject by such authority and such manner as may be prescribed by the rules. Then kindly come to, my lord, what was suggested, what was in 1935. My lord, something similar, but please see 50 subsection 2. I'll read, my lord, 1 also, because here the governor's discretion comes. Well, your lordships have seen yesterday, the president is not left with any discretion after 1919 Act till Article 111 as it stands today. I'm sorry, 75, which it stands today. 111 is a power of assent. But appointment is solely guided by the aid and advice of the Council of Ministers. In case of governor, my lord, the situation was different. The discretion continued throughout, but the discretion came to be circumscribed by use of words which were very consciously used. Lord, please see Council of Ministers in 1935. There shall be a council of ministers to aid, counsel of, and advise the governor in the exercise of his functions, ministers except in so far as he is by or under this act required to exercise his functions or any of them in his discretion, provided that nothing in this subsection shall be constrained as preventing the governor from exercising his individual judgment in any case, whether whereby or under this act he is required to do so. The governor in his discretion, please see the my lord, may preside at the meeting of Council of Ministers if any question arises whether any matter is or is not a matter as respects which the governor is by or under this act required to act in his discretion or to exercise his individual judgment, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion or ought not to have exercised his individual judgment. My lord, kindly note here, my lord, and park that contention, my lord, for a subsequent thing. 2 things. If he grants assent, can it be subject to the challenge? If he refuses to grant assent, both, my lord, were immune from the judicial review. Now, draft constitution, my lord, prepared by the constitutional advisor, Mr. Rao. There shall be a council of ministers with the prime minister at the head to aid and advise. My lord, even the provinces had prime minister. My lord, this, when we use prime minister, it was present day chief minister. There shall be council of ministers with the prime minister at the head to aid and advise the governor in exercise of his functions, except in so far as he is by or under this constitution required to exercise his functions or any of them in his discretion. If any question arises whether any matter is or so and so, my lord, same, that should not be called in question. Now, my lord, the draft prepared by the drafting committee. There shall be a council of ministers with the chief minister. Now, prime minister becomes the chief minister, my lord. Only nomenclature changes, my lord. Because there was no prime minister in 1935, the governor general was the whole and all, my lord, answerable to the crown. Chief minister at the head to aid and advise the governor in exercise of his functions, except insofar as he is by or under the constitution required to exercise his functions or any of them in his discretion. If any question arises whether any matter is or is not a matter as respect, my lord, same. Whether he exercises discretion rightly, wrongly cannot be gone into. That is, my lord. Now I come to, my lord, the Constituent Assembly debate on this And thereafter, my lord, the last debate I will read would be Article 200 and 201. Thereafter, my lord, the submissions start, but your lordships must have, my lord, the background in which these provisions were drafted and formulated, the manner in which they were formulated. What was conceived? My lord H.V. Kamath. Mr. President, sir, I move that in clause 1 of Article 143, the words except in so far as he is by or under this constitution required to exercise his function or any of them in his discretion be deleted. My lord, Mr. H.V. Kamath has always supported the provincial supremacy over central supremacy. He was proponent of that. He may have some personal equations also, my lord, and he always used to object. But this was his, my lord, idea of the constitution. If this amendment was accepted,
Influenced by the American system.
highly influenced, my lord, by the American, because some of, my lord, that tendency and trait, my lord, continues even till date. We still believe in the American Constitution and apply it, my lord, in the context of Indian Constitution also. And that, my lord, sometimes results into laying down the law, my lord, which creates more complications than solving them. Sir, it appears from the reading of this clause that the Government of India Act 1935 has been copied more or less blindly without mature consideration. Well, this is kind of a personal affront to Dr. Ambedkar that you have copied something without applying your mind. There is no strong or valid reason for giving the governor more authority either in his discretion or otherwise vis-a-vis his ministers than has been given to the president in relation to his ministers. If we turn to Article 61(1), we find it reads as follows: there shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his function. When you, sir, raised a very important issue the other day, Dr. Ambedkar clarified that his clause by saying that the president is bound to accept the advice of his ministers in the exercise of all his functions. But here, Article 143 vests certain discretionary powers in the governor, and to me it seems that even as it was bad enough. But now, after having amended Article 131 regarding election of the governor and accepted nominated governors, it would be wrong in principle and contrary to the tenets and principles of constitutional government which you are going to build in this country. It would be wrong, I say, to vest governor with these additional powers, namely discretionary powers. I feel that no departure from the principle of constitutional government should be favored except for the reason of emergency, and these discretionary powers must be done away with. I hope this amendment of mine will commend itself to the House. I move, sir. Then, my lord, Mr. Krishnamachari, my lord, who generally echoes the views of Dr. Ambedkar.
No, both of them were, Mr. Krishnamachari was also
members of the drafting committee. And it was, my lord,
most of the replies to the amendments are either replied by Dr. Ambedkar or by
T.T. Krishnamachari, my lord. Your lordships are right. I'm grateful. Mr. President, I'm afraid I'll have to oppose the amendment moved by my honorable friend, Mr. Kamath, only for the reason that he has not understood the scope of the article clearly and his amendment arises out of misapprehension. He again gives it back, my lord, in a polite language. Sir, it is no doubt true that certain words from this article may be removed, namely those which refer to the exercise by the governor of his functions, where he has to use his discretion irrespective of the advice tendered by his ministers. Actually, I think this is more by way of a safeguard because there are specific provisions in this draft constitution which occur subsequently where the governor is empowered to act in his discretion irrespective of the advice tendered by his council of ministers. There are two ways of formulating the idea underlying it. One is to make a mention of this exception in this Article 143 and enumerating the specific power of the governor where he can exercise his discretion in the articles that occur subsequently, or to leave out any mention of this power here and only state it in the appropriate article. The former method has been followed. Here, the general proposition is stated that the governor has normally to act on the advice of the ministers, except insofar as the exercise of his discretion covered by those articles in the Constitution in which he is specifically empowered to act in his discretion. So long as there are articles occurring subsequently in the Constitution where he is asked to act in his discretion, which completely cover all cases of departure from the normal practice to which I see my honorable friend Mr. Kamath has no objection. I may refer to Article 188. I see no harm in the provision in this article being as it is. If it happens that this House decides that in all subsequent articles the discretionary power should not be there, as it may conceivably do, this particular provision will be of no use and will fall into desuetude. The point that my honorable friend is trying to make, while he concedes that the discretionary power of the governor can be given under Article 188, well, that is 200. No, I'm sorry, 356. My apologies.
That's emergency.
Emergency.
Proclamation of
But,
emergency.
one interesting thing, my lord, an unfortunate thing, when 356 was being drafted by the Constituent Assembly, Mr. Kamath again, my lord, objected to that central government cannot be conferred power.
So Kamath was not in the drafting committee.
No, in the
When
Constituent.
when it was debated in the
Yeah,
Constitution.
when it was debated in the Constitution, he objected that central government should not have the power to impose precedence rule, and therefore Article 356 should not be there. To salvage the situation, my lord, it seems, Dr. Ambedkar ji says very wisely that I hope and trust that this article would remain a dead letter in the Constitution.
Yes,
That-
that's in his speech of 3rd of November 19.
3rd of November, your lordships are right. Your lordship remembers the dates also, my lord, correctly. I am grateful. Now, my lord,
Student of law.
my lord, we are all students of law. My lord, unfortunately, in the first government which was formed after the first election under Pandit Nehruji, Lord, the first 356 use came in Kerala state. Nambudripad was the popular leader and he was unseated under Article 356. I'm not going into the politics of it. But that debate was going on, my lord, in the parliament, and debate was whether it should be exercised or not. And Mr. Kamath, my lord, made one comment which, my lord, I think he should have avoided. He said that when the Constitution was being debated in the Constituent Assembly, Dr. Ambedkar said that this article would remain a dead letter word in the Constitution. Today, Dr. Ambedkar is dead, but the constitutional provision remains and it is being operated. So possibly he had some personal, my lord, equations. But be that as it may, my lord, we are not concerned with that.
One is entitled to have his own view.
No, view, my lord, certainly.
He might be having a view that why should a elected government in a province
Should be
should be
dislodged.
under the control of the central government through the governors.
No, he always, my lord, he was an absolute provincialist, that it should be completely immune from any central interference. All his, my lord, objections are leading to that provinces should be completely independent and like American model. My lord, he was genuinely, maybe as a theory.
Everybody was, we have the Constitution recently consisting of so many people having so many ideas.
Ideas, my lord. And Mr. Kamath was a former ICS officer, resigned and started participating in freedom struggle, and he had contributed a lot, my lord, and he, on his own right, my lord, elected to Lok Sabha. So he was not just a, my lord, troublemaker. He had a very strong view, and maybe some, my lord, we all have, my lord, likes and dislikes. I see no harm in the
On
provision.
Mondays and Fridays, we have 17 Supreme Courts.
Lord, if I may say on a lighter side, my lord, 32.
No,
No, that's not true.
On the lighter side. I see no harm in the provisions in this article being as it is.
Yes.
If it happens that this House decides that in all the subsequent articles, the discretionary power should not be there, as it may conceivably do, this particular provision will be of no use and will fall into desuetude. The point that my honorable friends is trying to, my lord, he ultimately says that let us wait till the actual conferment of powers in the respective spheres comes. Therefore, the serious objection of Mr. Kamath finds for mention of this exception is pointless. I therefore think that the article had better be passed without any amendment if it is necessary for the House either to limit the discretionary power of the governor or completely to do away with it. It could be done in the article that occurs subsequently, where specific mention is made, without which this power that is mentioned here cannot at all be exercised. That is the point I would like to draw the attention of the House to, and I think the article can better be passed as it is. Then Dr. P.S. Deshmukh. Mr. President, Mr. Krishnamachari has clarified the position with regard to this exception, which has been added to clause 1 of Article 143. If the governor is, in fact, going to have a discretionary power, then it is necessary that this clause, which Mr. Kamath seeks to omit, must remain. So first you decide whether he should have discretion or not. What discretion we will define when we deal with other articles. Sir, besides this, I do not know if the drafting committee has deliberately omitted or they are going to provide it at a later stage. And I would like to ask Dr. Ambedkar whether it is not necessary to provide for the governor to preside at the meeting. Malot, that may not be relevant. Malot, kindly turn the page over. Sri Alladi Krishnaswamy Iyer. Sir, there is really no difference between those who oppose and those who approve the amendment. In the first place, the general principle is laid down in Article 143, namely the principle of ministerial responsibility that the governor in various spheres of executive activity should act on the advice of his ministers. Then the article goes on to provide, except in so far as he is by or under this constitution required to exercise his functions or any of them in his discretion. So long as there are articles in the constitution which enable the governor to act in his discretion and in certain circumstances, it may be to override the cabinet or to refer to the president, this article as it is framed is perfectly in order. If later on the House comes to the conclusion that those articles which enable the governor to act in his discretion in specific cases should be deleted, it would be open to revise this article. But so long as there are later articles which permit the governor to act in his discretion and not on ministerial responsibility, the article is as drafted is perfectly in order. The only other question is whether first to make a provision, your lordships can skip. Now please come to the bottom. Dr. Ambedkar, my lord, replies, Mr. President, sir, I did not think that it would have been necessary for me to speak and take part in this debate after what my friend Mr. T.T. Krishnamachari had said on this amendment of Mr. Kamath. But as my friend Pandit Kunzuru pointedly asked me the question and demanded a reply, I thought that out of courtesy, I should say a few words. Sir, the main and the crucial question is, should the governor have discretionary powers? It is that question which is the main and the principal question. After we come to some decision on this question, the other question whether the words used in the last part of clause 1 of Article 143, that is present 163, should be retained in that article or should be transferred somewhere else could be usefully considered. The first thing, therefore, that I propose to do is to devote myself to this question, which, as I said, is the crucial question. It has been said in the course of the debate that the retention of discretionary power in the governor is contrary to responsible government in the provinces. It has also been said that retention of discretionary power in the governor smells of the Government of India Act 1935, which is the main was undemocratic. Now, speaking for myself, I have no doubt in my mind that retention on the vesting of governor with certain discretionary power is in no sense contrary to or in no sense a negation of responsible government. I do not wish to rake up the point because on this point I can very well satisfy the House by reference to provisions in the Constitution of Canada and Constitution of Australia. I do not think anybody in this House would dispute that the Canadian system of government is not fully responsible system of government, nor will anybody in this house challenge that Australian government is not a responsible form of government. Having said that, I would like to read section 55 of the Canadian Constitution, Article 55, where a bill passed by the House of Parliament is presented to the Governor General for the Queen's assent, he shall, according to his discretion and subject to provisions of this Act, either assent thereto in the Queen's name, or withhold the Queen's assent, or reserve the bill for signification of the Queen's pleasure. Three options. Pandit Hridaynath Kunzuru, may I ask Dr. Ambedkar, when the British North America Act was passed, Dr. B.R., this was kindly a sarcastic question, it seems. The Honorable Dr. Ambedkar, that does not matter at all. The date of the act does not matter. I mean, nearly a century ago. Dr. Mr. Kaman says that you are referring to.
Because I think Canadian Constitution must have been successor of the British North America Act.
Yes, which is 100 years ago. Therefore, he says that you are relying upon something which is 100
Relying
years.
on a provision which is a century old.
Century old, my lord, but without, while forgetting, I have nothing turns on that a provision which has withstood the test of time for 100 years would not become invalid or not acceptable merely because of the vintage.
That's what Dr. Ambedkar deals in the next
Dr.
paragraph.
Ambedkar says this. This is my reply. The Canadians and Australians have not found it necessary to delete this provision even at this stage. They are quite satisfied that the retention of this provision in section 55 of the Canadian Act is fully compatible with responsible government. If they had felt that this provision was not compatible with responsible government, they have even today, as dominions, the fullest right to abrogate this provision. Dominions means dominions of the Commonwealth, my lord, under the sovereign. Dominions, the fullest right to abrogate this provision. They have not done so. Therefore, in my reply to Pandit Kunzuru, I can very well say that the Canadians and Australians do not think that such a provision is an infringement on the responsible government. Then Loknath Sharma, on a point of order, sir, are we going to have the status of Canada or Australia? Or are we going to have a federal republican constitution? Then Dr. Ambedkar, I could not follow what he said. If, as I hope, the House is satisfied that the existence of a provision wasting a certain amount of discretion in the governor is not incompatible or inconsistent with responsible government, there can be no dispute that the retention of this clause is desirable and, in my judgment, necessary. The only question that arises is, Pandit Kunzuru, well, Dr. Ambedkar has missed the point of the criticism altogether. The criticism is not that in Article 175 some powers might not be given to the governor. The criticism is against vesting the governor with certain discretionary powers of a great nature in the article under consideration. Dr. Ambedkar, I think he has misread the article. I'm sorry I do not have the draft constitution with me, except insofar as he is by or under this constitution. Those are the words. If the words were except whenever he thinks that he should exercise this power of discretion against the
It is
wishes,
implied that wherever the subsequent articles
provides,
provide for a discretion,
yes,
that power will be restricted only to those
does
articles.
not leave it to the governor's sole discretion
discretion that
to
he can-
decide where I will be exercising my discretion. That's my lord, what Dr. Ambedkar.
Not an unruly horse.
Yes, my lordships are right.
Only wherever in a subsequent article discretion is provided,
Yes, my lord.
in those articles, in the discharge of those functions, only he can exercise his discretion and not otherwise.
No, otherwise, my lord, by aid and advice.
Clarified, where he said therefore article 143 will have to be read in conjunction with some other articles
Which specifically
reserve the
reserve-
power to the governor.
Yes,
It is not a general clause giving the governor power to disregard the advice of the ministers in any matter in which he find he ought to disregard.
disregard. Correct.
There I think lies the fallacy of the argument of my honorable friend.
a
And
policy of
that
argument.
is what T.T. Krishnamacharya also.
Qualified that how this power is regulated within the framework of the constitution.
Will come further.
That is what Mr. T.T. Krishnamacharya also said, that even subsequent, when we come to discussion with the subsequent articles, and we find that the vesting of the discretion with the governor is not necessary, then we can have a relook at this article.
Absolutely. That's what, my lord, it means. My lords are right. Now, next page. Therefore, as I said, having stated that there is nothing incompatible with the retention of the discretionary power in the governor in specified cases with the system of responsible government, the only question that arises is, how should we provide for the mention of this discretionary power? It seems to me that there are three ways by which this could be done. One way is to omit the words from Article 143, that is 163 today, as my honorable friend Pandit Kunzuru and other desire, and to add to such articles as 175 or 188, that is 200, and the emergency powers, or such other provisions which the House may hereafter introduce, vesting the governor with discretionary power, saying notwithstanding Article 143, the governor shall have this or that power. The other way would be to say in Article 143 that except as provided in Articles so and so, specifically mention Article 175 or whatever they are. But the point I'm trying to submit to the House is that the House cannot escape from mentioning in some manner that the governor shall have discretion. Whether you put it under 163 or 200 later, that's not relevant. The principal question as a principle to be decided is whether governor should be given some discretion or not. And my lord, thereafter 163 retains the discretion. Then, my lord, now the matter which seems to find some kind of favor with my honorable friend Pandit Kunzuru and those who have spoken in the same way is that the word should be omitted from here and should be transferred somewhere else, or that the specific article should be mentioned in Article 143. It seems to me that this is a mere method of drafting. There is no question of substance and no question of principle. I personally myself would be quite willing to amend the last portion of clause 1 of Article 143 if I knew at this stage what are the provisions that this Constituent Assembly proposes to make with regard to vesting of the governor with discretionary power. My difficulty is that we have not yet come either to Article 175 or 188, nor have we exhausted all possibilities of other provisions being made, vesting the governor with discretionary power. If I knew that, I would very readily agree to amend Article 143 and to mention the specific article, but that cannot be done now. Therefore, my submission is that no wrong could be done if the words as they stand in the Article 143 remains as they are. They are certainly not inconsistent. Conferment of discretion.
Is there a revisitation of this debate after the debate of 175 and 188?
No,
Yes.
No, there isn't.
Yeah, yes.
It's not there.
There isn't.
Lord,
So
in-
at that time, we didn't have anything like
Lord, in when
impact assessment of a statute. Or as of now,
Your
if
Lordship.
we see the amount of litigation it has thrown by having provisions of this nature, perhaps that could tell us whether the vision was right or not right. Because the validity or correctness of a thought would come by its performance.
how it
End of
operates,
today, experience.
how it operates,
Of
how
the
it has
amount of
operated.
litigation it would have thrown, which could perhaps be
My lord,
avoided.
I
with
may make
certainty and
one-
clarity.
Lord, I may make one thing clear. While reading this debate, my lord, it is not my intention to argue and ultimately, my lord, raise a contention that governor has absolute discretion. That's not the purpose of reading this. The purpose of
Your argument is that under this article 163, the power of the governor to exercise his discretion, wherever the subsequent articles reserve the discretion in him, the governor would be entitled to exercise the discretion, and Article 200 is one of such articles where a discretion is provided to the governor.
my lord, by very nature of the article, it is so provided. And I'll, my lord, come to that. And when I read, my lord, Article 200 debates, my lord, that comes out. Because, my lord, There are, as my Lord Justice Nasima rightly says, we understand the constitutional principles based upon how the function, how it has operated, how it has worked. My Lord, there are some conventions which are also developed. For example, my Lord, 163 says that the governor will act on the aid and advice of the Council of Ministers. Now, my Lord, when the first person is to be called to form the government, there is no Council of Ministers. So the governor, by very nature of the act, will have to act on his discretion. My Lord, when there is a dispute, which leader has the majority in the house?
We have some experience as to in what manner some of the honorable governors have exercised their discretions, leading to so many litigations.
My Lord, I must, my Lord, tell your lordships and my Lord, put a little word of caution for myself also. My Lord, if we go by some example,
We are not going by that.
I understand. No, I am saying something else. Lord, Indian democracy is a mature democracy. There may be aberrations, my Lord, on individual cases. But by and large, the democracy under this very constitution has worked very effectively. And that, my Lord, I have personally witnessed, my Lord, during COVID period. During COVID period, my Lord, the Indian democracy and how the center, province, federal balance is envisaged what was at display. Lord, irrespective of the party in power in the center, which was Lord NDA, BJP, etc., all state governments ruled by Congress, ruled by communist, everyone, they were on the same page with the Honorable Prime Minister. There was no dispute, difference, and they used to call each other. That's the way democracy works. That you have debate, you have deliberation, you have consultation, you give suggestions, you take suggestions, and everyone was on the same page. My Lord, since I was appearing, my lords, I know it for sure that chief ministers of those states whose chief ministers were very critical, and it was their right to be critical of the center. My Lord, they used to call the prime minister at 2 o'clock that this is what we are needing, and there would be a serious problem, and the thing would reach. And my Lord, the counter thing also. The government also responded in a matured way, except, my Lord, one or two exceptional states. But everyone, my Lord, because all these people, my Lord, irrespective of the political leanings, they have, my Lord, political experience of 30, 40, 50 years. They have that political maturity, my Lord, to decide. So, my Lord, it would be really hazardous, my Lord, to even examine constitutional interpretation based on certain aberrations. There are ambitions, there are, my Lord, pitfalls, but that is to be taken care of on a case-to-case basis. One cannot interpret the constitution based on the worst example because, Lord, hard cases always results into laying down of bad laws. That's, my Lord, that's a settled principle throughout all jurisdictions.
If not otherwise, hard cases make good law.
But I would not respond to this. Then Dr. Ambedkar. Of course, there is because we do not want to waste the precedent with any discretionary power because the provincial governments are required to work in subordination to the central government. And therefore, in order to see that they do act in subordination to the central government, the governor will reserve certain things in order to give the president the opportunity to see that the rules under which the provincial governments are supposed to act under the according to the constitution or in subordination to the central government are observed. Please mark this, my lord. This is, my lord, the fundamental foundation of, my lord, the Constituent Assembly, and this is what was the thought, the principle of constitutionalism in the mind of Dr. Ambedkar, that they must be free to take decision, but there must be some level of, Lord, deference to the central government because we have a quasi-federal constitution. Then H.V. Kamath, will it not be better to specify certain articles in the constitution with, my lord, he continues, my lord, with his objection, my lord. I may skip that. Now, my lord, kindly come to present, my lord, green is Article 163, which is at present, that normally, I'm paraphrasing, the governor will act in accordance with the aid and advice of the Council of Ministers, and governor must do it. We are not arguing A versus B. I'm assisting the court because we are seeking your lordship's opinion. So I'm just giving what is my reading of the Constitution. Governor will have to act on the aid and advice except where he is having discretion, either conferred by the constitutional provisions or by the very nature of the power which he is exercising. Then, my lord, 200 and 201, and this is the last provision which I will bother your lordships with the Constituent Assembly debates, my lord, and then I'll come to other submissions, my lord. Please see Government of India Act 1919. This is very relevant because this is directly in question. This is precursor to Article 200. What are the options available for the governor when a bill is presented to him? Is he supposed to sign it as an automated person, as my lord, one word which is
The postman.
he's not a postman. That's what, my lord, my effort would be, and that comes out from the constituent debate. The very nature, in the very manner in which Article 200 is couched, the language which is used, it gives him options. And when I am given 3 options, means I have been given discretion to choose one of them. The word discretion being used or not used will make no consequence if I am given 3 options or 4 options. I'll show that, my lord. Please come to, my lord, section 12 of Government of India Act 1919. And this would be, my lord, relevant, directly relevant for the present purpose. Where a bill has been passed by a local legislative council, the governor, lieutenant governor, or chief commissioner may, instead of declaring that he assents to, or first option, my lord, is granting assent, assents to, or withholds his assent from the bill. Second option, return the bill to the council for reconsideration. Third option, either in whole or in part, together with any amendments which he may recommend, or in cases prescribed by rules under the Principal Act may, and if the rules so require shall, reserve the bill for consideration of the Governor General. That is precedent. So 4 options: assent, withhold, return to the House, or refer it to the Governor General, which is the present day President, for his assent. Where a bill is reserved for the consideration of the Governor General, the following provisions shall apply when it goes to the President in the present terminology. The Governor, Lieutenant Governor, or Chief Commissioner may, at any time within 6 months from the date of reservation of the bill, with the consent of the Governor General, return the bill for further consideration by the Council with a recommendation that the Council shall consider amendments thereto. The President can refer it back. Instead of the Governor choosing, Governor may choose that I will send it to Governor General, then namely the President. He can say that no, I send it back. B, after any bill so returned has been further considered by the Council, together with any recommendations made by the Governor, Lieutenant Governor, or Chief Commissioner relating thereto, the bill, if reaffirmed with or without amendment, may be again presented to the Governor, Lieutenant Governor, or Chief Commissioner. Any bill reserved for the consideration of the Governor General shall, if assented to by the Governor General within a period of 6 months. Time limit was prescribed by the Act itself for the President equivalent, namely the Governor General, to act. And I'll come to, my lord, that as soon as possible part. That is also, my lord, taken care of. From the date of such reservation become law on due publication of such assent, in the same way as a bill assented to by the Governor, Lieutenant Governor, or the Chief Commissioner, but if not assented to by the Governor General within such period of 6 months, shall lapse. Consequence also provided, time limit stipulated, and consequence provided, meaning thereby the time limit is mandatory, not discretionary. and be of no effect unless before expiration of that period, either one, the bill has been returned by the governor, lieutenant governor, or chief commissioner for further consideration by the council, or in the case of the council not being in session, a notification has been published of an intention so to return the bill at the commencement of the session. The Governor General may, except where the bill has been reserved for his consideration, instead of assenting to or withholding his assent from any act passed by local legislature, declare that he reserves the act for the signification of his majesty's pleasure. Well, this was a standalone provision because there was someone above the Governor General, the present day president. Here, my lord, president is
There's no one above.
no one above. Assenting to withhold, my lord, therefore, my lord, and I would come to that, my interpretation of the term withhold is that it is not given effect to it falls through. That's how the Supreme Court has read. Falls through. And please, my lord, read, my lord, these provisions in this context. Now, 13. Provision for case of failure to pass legislation in Governor's Legislative Council. Where a Governor's Legislative Council has refused leave to introduce or has failed to pass in a form recommended by the Governor any bill relating to a reserved subject, that is, my lord, state list, the Governor may certify that the passage of the bill is essential for the discharge of his responsibility for the subject, and thereupon the bill shall, notwithstanding that the council have not considered thereto, be deemed to have passed. There is a deeming provision made by way of a statute. Deeming provision of a bill having been passed can be made either by a statute or by amendment of the Constitution. I'll come to that little later, my lord, whether that can be done by a judicial verdict, that's a separate argument. And shall, on signature by the governor, become an act of the local legislature in the form of the bill as originally introduced or proposed to be introduced in the council, etc. My lord, rest of them may not, my lord, assist your lordships. Please come to, my lord, my lord, 72 is the draft bill of the constitutional advisor. And my lord, kindly come to, my lord, first 70, my lord, Assent. This is again 1935 Act. What I read was 1919 Act, now 1935 Act. A bill which has been passed by the Provincial Legislative Assembly, that is, my lord, present day State Assembly, or in case of a province having a legislative council, has been passed by both chambers of the provincial legislature, shall be presented to the governor, and the governor, in his discretion, my lord, the other side would harp upon this, that there was a discretion which now no longer exists in Article 200. Therefore, I am highlighting, my lord. In his discretion, shall declare either that one, he assents in his majesty's name to the bill, second, or that he withholds assent therefrom, third, or that he reserves the bill for consideration of the Governor General, that is, my lord, President, provided that the governor may, in his discretion, return the bill. This is the fourth option. Return the bill together with a message requesting that the chamber or chambers will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendment as he may recommend in his message. And when a bill is so returned, the chamber of chambers shall consider it accordingly. It stopped here. So three options, he can straightway say, I withhold, I grant assent. He can say, I withhold the assent, meaning thereby I will show the bill falls through. Third, he may say that no, there is some repugnancy, some violation of fundamental rights, I refer it to the president. And fourth option, in his discretion, he can say that no, it is curable defect in the bill, and therefore I return it with my message that this particular provision is repugnant. There is already a central law occupying the field, and therefore you please reconsider. Or even desirability, that instead of 19 years of age, you consider 21 or any such thing, my lord. I'm just not giving hypothetical examples. But 4 options were available to the governor then. Now, my lord, draft constitution, para 72, when Mr. B.N. Rao, Dr. B.N. Rao, my lord, prepared the draft constitution. A bill which has been passed by the provincial legislative assembly, or in case of a province having the legislative council, has been passed by both houses of the provincial legislature, shall be presented to the governor, and the governor shall declare either that he assents to the bill, 1. Yes. Three 56 doesn't use the word discussion. Yes. My lord, I was reading 147 as suggested by, my lord, by the constitutional advisor. A bill which has been passed by the provincial legislative assembly, or in case of a province having legislative council, has been passed by both houses of provincial legislature, shall be presented to the governor, and the governor shall declare either, the first option, he assents to the bill, or second option, that he withholds assent therefrom, third option, that he reserves the bill for consideration of the president, provided that where there is only one house of legislature of a province and the bill has been passed by both the houses of the governor, houses, the governor may, in his discretion, it was initially there, in his discretion, return the bill together with a message requesting that the House will consider the desirability of introducing, I'm not reading it, it's the same,
Almost same.
except there is no consequence provided. If the House returns it back, now it says, governor shall not withhold. It comes, my lord, subsequently. Now, my lord, the committee, the drafting committee,
So, in effect, if on the second occasion, the legislature again reiterates, then the governor will not have any option but to give it as.
not at this stage.
No, no.
No, I'm sorry, it was there. The governor shall not withhold assent therefrom. He has no option.
So it is quite in the negative.
Yes.
It gives a mandate that if it is passed,
You have to grant assent.
like the college,
That could have been used, my lord. That's a separate argument. I'm sorry, my lord,
like the college. Fortunately, we are not on that issue now, so.
Taken the same language.
I cannot say anything.
No, we are not on that issue. Let us stick to the case before us.
Now, my lord, please come to, my lord, now draft prepared by the drafting committee at page 145. The same. No real change, your lordship can take it from me. My lord, the drafting committee also goes this way, my lord. Then, in the draft constitution prepared by the drafting committee, now 201, your lordships have
175 and 176.
the 20, 200 and 201 present. That is, my lord, the subject matter of, my lord, the reference and your lordship's advice. 201, my lord, was drafted by drafting committee like this. When a bill is reserved by a
So
governor
earlier, there was only one section, now it is bifurcated into two sections.
into two sections. Because now we have a president and president has a different regime where he is bound by the aid and advice. He does not have, my lord, the choice, etc. I'll come to that. Please have a look. When a bill is reserved by a governor for consideration of the president shall declare either that he assents to the bill or that he withholds assent therefrom. Two options. Third option, provided that where the bill is not a money bill, the president may direct the governor to return the bill to the house, or as the case may be, the houses of the legislature of the state, together with such a message as is mentioned in the proviso to the last preceding article. And when a bill is so returned, the house or houses shall reconsider it accordingly. Please mark this, my lord, within a period of 6 months. This continues. Whenever Constitution intended to provide for a timeline, the Constitution has provided for. This continues even in the present Article 201. And therefore, it is not permissible to lay down any timeline in other articles. I'll come to that. That's a separate point, my lord. Now, my lord, the debate, this debate, my lord, both of us would be relying upon. The other side would also, in fact, there cannot be any other side when it is a presidential reference. But, my lord, the other side point of view, my lord, they would also,
Other point of view.
other point of view, my lords, they would also rely upon to say that the discretion was taken away. My lord, apropos, my lord, Justice Narsimha's question, whether subsequent debates throw any light on that discretion or not. Because Dr. Ambedkar says
No,
that
no,
whenever...
that was not what my learned brother pointed out. That after the subsequent articles were discussed, like 200 and 201, wherein discussion was provided, was there a relook on the earlier article which provided for discretion?
No,
There was no.
there was none, but it comes in 200. Because
Because when T.T. Krishnamachari and both Dr. Ambedkar, they say that if in subsequent articles, if we do not provide for discussion, then we may have a look at this article.
We will see, because the wording says, my difficulty is that, I'm quoting from his state.
I do not know what...
Difficulty is that we have not as yet come either to Article 175 or 188, nor have we exhausted all the possibilities of other provisions being made, vesting the governor with the discretionary power. He said as and when. We'll see at 200. in all
Yeah, your
probability.
lordships are right. My lord, that one Article 175 debate is...
It was not necessary because in the subsequent articles, they provided for discretion. So there was no question of
Absolutely.
again having a relook at.
But, my lord, this is the debate. Page 146 is that debate which
That's
my
it.
lords were referring
That's
to.
it.
But, my lord, please bear in mind that in 163, the discretion remained. That aid and advice except subject to, my lord, by or under the Constitution. And I may tell your lordships, subsequently, there are no articles which specifically uses the word discretion. Subsequent to Article 163, there are no articles which confers discretion. But after reading this, my lord, debate, my submission for your lordship's consideration is going to be that if the article itself gives him options to choose from, use or not use of the word discretion does not matter, because he is that you choose from either of these four.
Then the discretion has to be exercised among the options given in that article.
Lord, I'll come to that. I'll come to that.
If the article provides for 4 options,
Yes.
then the discretion would be restricted to only one of those 4 options.
Correct. I bow down. It cannot be beyond that. Governor is bound by one of those 4 options. Governor is bound by one of those 4 options. But which option to choose from,
It is discretion.
it is his discretion. My lord, for example, for the purpose of granting assent, the Council of Ministers would always say that grant assent, it is our bill. So there is no question of, my lord, he is using discretion.
That will be relatable only to that part of the question where it is sent back to the assembly for reconsideration. And it is coming back to him. At that second stage, will he
No
be
discretion.
entitled to send it back to the president for his approval?
There he would have the
That
discretion.
is where you are talking about.
That is there, he would have the discretion. He cannot withhold it.
That's your argument.
But, yeah, that's my argument. My lord, but the problem has arisen because of state of Punjab judgment. Not the state of Punjab judgment. I'll come to that, my lord.
But the issue relating to timelines is not relatable to the options.
No, that's a separate point. That's a separate. Your lordships are right. Timeline has nothing to do with the option or discretion, etc. Since I was there, since I was showing the provision where the Constitution itself prescribed time limit, since I was reading the provision which itself provided for time limit, I just as a reference said that whenever the makers wanted, they have provided for the time limit. And if it is required, it can be done by a constitutional.
Timeline which you are referring to is for reconsideration by the legislature.
Legislative timeline.
That is not a timeline given
executive
for the governor.
Exactly, that's my case. That's my case. That now you are reading something which the Constitution has provided, not provided.
So ultimately, probably, Mr. Solicitor, possibly there can't be any serious dispute with regard to the 3 or 4 expressions used in 200. Assent, shall declare, assent, or
Withhold,
withhold, send to the president for advice. And third is that may return. But
Return.
word in his discretion has been omitted on the suggestion of Dr. Ambedkar. Earlier the draft was
about.
his discretion.
Your
made.
lordships are absolutely.
Dr. Ambedkar advised that no, we should delete these words, those were deleted.
Yes.
So these are the options available. Probably the central point of debate will be, what do we mean by withhold?
I'm grateful.
That will
I'm
be the
great.
central point.
I'm
Is
grateful.
it withhold means that after withholding it means that you are not assenting and you are for the time being withholding yourself. Withholding for what? Either to return to the assembly for reconsideration with your message or advice,
Punjab judgment says.
or you send to the president. For example, there may be a draft bill touching upon or encroaching upon the power of the parliament under list 1. Governor is well within his right to say, state assembly can't pass it. So therefore, you can either advise them that, look here, you need to look into it. You can't encroach upon list 1. This is not within your domain. Or he will send to the president of India saying, the state has attempted, the state legislature has attempted like this. In my considered opinion, such a bill will fall under entry number so and so, for which state legislature is incompetent. And honorable president will take the final call on that. The only issue will be this one. Probably
Yes,
this
yes.
is not
Lord, only issue will be, and I'll come to that after reading this.
how much time now this entire process should be undertaken. That is probably central point.
The time for completing the procedure. I'll come to
Form an
that.
opinion.
I'll come to, but that's a separate, my lord, argument.
But
Please allow me, my lord, but since your lordships have given a very right and apt example, the withhold, my lord, whether withhold is a temporary act of withholding, or as the Supreme Court through 5 judge and 7 judge benches have said, that withhold means the bill falls through. Because there are circumstances where, suppose, my lord, normally the legislature is not expected or is not supposed to pass egregious, my lord, something, my lord, very extraordinary bills which are beyond their competence. But suppose, my lord, how we read the Article 200. My lord, suppose a border state passes a legislation which deals with our external affairs, that will permit a particular country's people to enter or not to enter.
You
What?
can respond to these.
Give me a minute.
As per the way you want. You are only pointing out that rest of the this discussion ultimately leads to the final bill at page 150, and probably thereafter this issue arises.
Your lordships are right. My lord, then he cannot assent He cannot refer it to the president because it's not a repugnancy issue. He cannot return it to the house because once he returns it to the house and house repasses it, then he is bound, he cannot withhold it. Then he will have to withhold, my lord. And I have given the examples. It is to be used rarely, sparingly. But that's the way the situation is.
Sorry, what is your submission?
Lord, there can be
There are four instances, four options. Either he assents to the bill or withholds assent therefrom. And that he reserves the bill for the consideration of the president.
president.
So according to you, the withholding of the assent, the second option, can be unlimited.
It's not, my lord, a temporary withholding. My lord, can I go, my lord, a little, my lord, in the chronology so that I can make that point good? Yes, my lord, my answer is yes. That withhold means the bill falls through. That's how, my lord, the 5-judge bench and 7-judge benches have understood, my lord, this Article 200. And I have given examples.
But then, if he doesn't, if he doesn't exercise the option of resending the bill for reconsideration to the governor, still he can withhold it for a time immemorial.
It dies. It dies. It is to be used rarely, but the power is conferred. My lord, rather than, my lord, entering into this debate right now, can I, my lord, just give the background?
Like for example, in the Kerala, in the Tamil Nadu case, 10 out of 12 bills, after the first consultation, he said, I am withholding these 10. But you are not talking about a situation where he would communicate saying that I have
It's a declaration. Lord, before I start the arguments on this point, I am skipping that debate. Lord, debate takes
That you will deal with those aspects independently, is what you're saying.
aspect of.
Aspects on timelines.
He want, he,
Yes, Lord, that's a separate issue. I am-
he just wants to explain us the history as to how these
Yes, yes,
provisions came into effect
Yes.
and submission later on.
yes.
Now, my lord, I am on interpretation of Article 200 and 201. Please come to page 150. Let me read it, my lord. The way we believe it requires to be read. 200, assent of the bills. When a bill has been passed by the Legislative Assembly of a state, or in case of a state having Legislative Council, has been passed by both houses of the Legislative Assembly, it shall be presented to the governor. So this is the first condition. And the governor shall declare. This is his obligation, constitutional obligation. He has to make a declaration. What? 4 options. Either that he assents to the bill, or second option, he withholds assent, withhold assent therefrom. Third option, or that he reserves the bill for consideration of the president. I'll come to my lord, Article 254, which says that this reference would be necessary only if the bill is repugnant to some central law, not otherwise. He cannot refer it for any other reason. That
Referring to the president.
yeah, then he can refer it. He has to refer it. That's the mandate. My lord, if there is a repugnancy with the central law, he will have to refer it. Now the fourth option, provided that the governor may. It doesn't say shall. Governor may. And something would turn when I, my lord, point out.
Mr. The 1 minute. Let's read it again, the first part.
I'll read, my lord. When a bill has been passed by the Legislative Assembly of a state, or in case of a state having Legislative Council have been passed by both houses of legislature of the state, it shall be presented to the governor,
Right.
and the governor shall declare either.
Yes, so declaration has to be in both cases, whether he assents or whether he withholds.
All 4 cases,
No.
all 3 cases.
Yes,
Yes.
that declaration has to be there.
100%.
It is not that he will not make a declaration and withhold it.
Yes, he will have to declare that I have withheld it.
Correct.
Bound, I bound out. That is the only way it can be read. Yes, he has to declare. One of the 3, he will declare either first option, he assents to the bill. Then no dispute will remain.
So according to you, if he declares that it is withheld, the bill is said to be failed.
Yes. It falls through. Supreme Court says, 5 judge and 7.
In other words, what you are saying is, when it is communicated to the assembly that it is withheld, it cannot be placed back before the assembly for reconsideration.
Correct.
Yes.
What you're saying?
Yes.
Wording, the meaning of the word
Refusal
withholding
to
means.
or grant assent.
There will be a declaration in public domain assigning the reasons that these are the reasons I am withholding.
Reasons, there is a separate issue. Declaration that I withhold. Because sometimes my lord, reasons can be in national security.
So, but then could we not be giving total powers to the governor to sit in and appeal over the?
For my lord, with profound respect. Lord, the powers are given by the Constitution.
Otherwise, the government elected with the majority will be at the whims and fancies of the governor. We will say that no.
Before I answer that, lord, first of all of us derive our powers from the Constitution.
Yes, of course.
We neither give nor take away. Nobody can, my lord. There are 3 organs. But it's not, my lord. Let me, my lord, complete. Then, my lord, I'll be able to answer your lordship's questions, my lord, more effectively. Right now, your lordship's first brush reaction is that if withhold is held to be
A power to reject the bill.
power to reject the bill, it is there. That's my case. I'll have to make it good. Provided that the governor may, not the 4th option.
Yes.
So kindly park that question. I'll answer that question. And
According to you, even if the governor feels that the bill is not correct or lacking something, it is not necessary for him to exercise the powers under the proviso. He may bypass the proviso and still hold that.
therefore, I am requesting your lordships, to park that question right now. That's not my case. That's not my case. That's the extreme case visualized in Tamil Nadu, and whether we like it or not, we are burdened with the Tamil Nadu facts. I'm arguing dehorse Tamil Nadu facts. Correct, my lords? So he has three options. He will have to make a declaration that I assent. I withhold, which according to me, bill falls through. I'm not accepting that. I'm taking that argument head on. Yes. Third, if it is repugnant because of Article 254 with some central act,
He has to
you
go to
will
the
have
president.
to refer. But there can be an act with the rather bill, which is of such a nature that it may have some provisions which are repugnant. It may have some provisions which may violate somebody's fundamental rights, or it may have some provisions which, according to governor, is not desirable. Desirable. Then, kindly, have
No, we are not responding.
no,
We
your
didn't say anything.
lordship, smile is a good, is a very.
I am always smiling throughout the day.
Please bear with me.
I can't help it if the God has given me with a smile.
No, it's a good thing, my lord. It's a good thing, my lord. Your smiling judge is always, my lord, pleasing to argue before, my lord, and all your lordships are always smiling.
Consider, just bear in your mind that there are two places in which the expression withhold comes in the Constitution, in Article 200. If your argument withhold enables leads to a bill falling flat, once the governor says that I am withholding, then you will have to give it the same meaning in the first proviso last words. Because it again says when it is represented to the governor for assent, the governor shall not withhold assent. So therefore you are saying if once it is fallen, then where is the question of a second occasion? Constitution is saying at this stage you shall not. Keep in mind and answer.
Yes, yes. My lord, can I request for a 5 minutes comfort break, my lord, if your lordships can?
Yes, yes.
Can I go and come back, or?
Yes, so in the meantime, if you want us to.
Yeah.
We'll come back at
5 minutes, my lord.
12:30, 12:22 now.
I am grateful to your lordship for the accommodation.
We hope you are comfortable now.
Yes, yes.
Relief. Yes.
My lord, may I request your lordship? My lord, I have understood, my lord, what is.
Yes, no, we will not interrupt you. Yes.
No, I'm not saying. Yeah, it's not an interruption, my lord, your lordship. That dialogue, my lord, only permits us, my lord, or
So you first read whatever you want to, and then
my lord, first, my
then
lord,
develop your summary.
let me, my lord, say that the question of withhold, whether it is permanent or a temporary till he returns, is the question. I will show your lordships, my lord, some examples.
So you have said that it is already covered by Punjab judgment.
No, the Punjab judgment, without noting 5 judge and 7 judge judgments, it's a 3 judge judgment. My Lord Justice, Chief Justice Chandrachud, Justice Pardiwala, and Justice Manoj Mishra, without referring to any of the binding 5 judge or 7 judge judgments, have recorded, my Lord, the finding that withhold means you have to you read it with the proviso, which I will show and demonstrate, at least attempt to demonstrate that it's.
In ignorance of the earlier 5 judges and 7 judges.
Yes, and I want to show that and what earlier judgments have said on the question of withhold.
This is what
Thereafter,
you are
my lord,
saying. He has read it, took the meaning from the proviso to give a, to read the
the
withhold.
last part, withheld, my lord, with a while, my lord, immediately answering. If the way in which, my lord, the Punjab judgment, my lord, understood article, the last part would have been, he shall grant his assent. He shall not withhold. My lord, the power to refer still remains, but that's not, my lord, right now the question. My lord, I have read, my lord, Article 200. Now, Article 201. What happens, my lord, when bill is referred by the governor to the President of India? That is 201. When a bill is reserved by the governor for consideration of the President shall declare either that he assents to the bill or that he withholds assent therefrom. Withhold means, my lord, bill falls through. I'll show, my lord, from the judgment. Provided that where the bill is not a money bill, the President may direct the governor to return the bill to the House, or as the case may be, the houses of legislature of the state, together with such a message as in mentioned in the first proviso to Article 200. And when a bill is so returned, the House or houses shall reconsider it accordingly within a period of 6 months. Please mark, my lord, as a separate point, Constitution provides for a time limit. The date of receipt of such message, and if it is again passed by the House or the Houses with or without amendment, it shall be presented again to the President for consideration. It does not say here that thereafter President shall not withhold it. Meaning thereby the ultimate power of the President to withhold means.
So this exercise of returning can continue as many number of times as the president desires. Correct.
And he is thereafter not under an obligation not to withhold, as my lord
As
provides.
the 200 or
200, my lord, provides. Now, please see, my lord, what is, my lord, how I, my lord, beg to interpret this, my lord. My lord, at page 152, I have given, my lord, I am not reading, several provisions, my lord, where governor exercises executive powers.
Yes.
He exercises legislative powers. My lord, there are powers, my lord, which are quasi-legislative in nature. I may not, my lord. Please come to 154. And then immediately I'll switch over to the judgments, my lord, on this. On true construction of Article 200, the governor is entrusted with 4 options. My lord, I have narrated.
You are referring
Neither
to page?
context.
Page number?
154. I'm sorry, my lord, 154.
151.
154.
154.
154. Neither contextually nor textually, it is possible to conclude that the term withhold will have to be read as a temporary suspension of power of granting assent till first proviso works out. There is no concept of temporary withholding of any bill. If the framers of the Constitution would have intended to link the term withhold in the main part of Article 200 to read only in the context of the first proviso, two things would have been provided. A, the term withhold in the main part would have been qualified by the term subject to first proviso mentioned therein. In the main part, they would have said that you withhold subject to following the provision. And B, the first proviso would have mentioned that the bill so withheld shall be reconsidered by the House, which is not that. I am going on textual interpretation, Manoj. In other words, the power of withholding in the main part of Article 200 is an independent and unqualified power. However, out of three possible powers contemplated in the main part, having not been resorted to by the governor, by giving an opportunity to the assembly under the first proviso, the governor cannot fall back again on the main part and withhold the bill passed once again, with or without suggestions of the governor. In other words, if the governor wants to withhold the bill, that is resultantly the bill falls through. Please mark these words. These are the words I have borrowed, which are used consistently by the larger benches. The bill falls through, he has to do it at the outset. If he chooses not to exercise that power at the outset, he is denuded of that power if he chooses to return the bill under the first proviso, because of the last part of the first proviso. The governor is expected and empowered to withhold the bill in the main part of Article
It has been held by five judges bench.
5 and 1/7 judge also.
7 judges.
No, my lord, all are 5. I stand corrected. My lord, there is a judgment of Samsher Singh, but that is on discretion, not on withholding. Samsher Singh is 7 judge.
How do you must have dealt in your argument,
Right.
what is the meaning of word withhold?
It's
coming.
It's coming. Therefore, my lord,
Flexible नहीं है, इसके लिए बोला था.
my lord,
So, give the meaning.
Why has this word withhold being used in this?
yes, my lord, withhold has, my lord, its own meaning. And I will show, my lord, why this has a meaning and why that meaning is required to be given in the main part. And what kind of rare contingencies which are contemplated, where you cannot assent.
Normally, the concept of withholding is suppose there is some dispute. There of 2 crore. Out of that, 1.5 crores is undisputed. Normally, 1.5 would be paid and 50 lakh would be withheld till the dispute is.
My lord, that's not.
No, cannot be. In a
Request.
common parlance, that I understand it.
But that's in a commercial parlance, yes. But that we withhold this issue. Right now, we withhold the file. But that's not the way in which it is used. That's not the way in which and it will become very clear.
Is there any debate on the word withhold? The Constitutional Assembly debates why this word withhold is being used.
No. Because it has come.
Otherwise, simply they could have said either he grants assent or he refuses to grant assent. Why withhold has been used?
Right from, look, this word has been taken from 1919 Act, 1935 Act, and now present Act. So it is not debated in Parliament. We will have to independently examine. Your Lordships will have to examine. We will assist your Lordships in that. But I'm just right now, my lord, please consider, without keeping in mind some egregious, my lord, facts where someone may withhold without any application of mind or just out of political frustrations. I'm just trying, my lord, to say that the governor is not that way powerless. He has 3 options, subject to the 4th option being exercised, my lord, and all 4 options are independent of each other. Now, please see, the governor is expected, para 97 at page 155. The governor is expected and empowered to withhold the bill in the main part of the Article 200 when he finds that the entire bill is beyond the legislative competence of the legislature. Then he can't return it. If the entire bill covers, my lord, say, atomic energy or defense or external affairs.
Then you can send it to the president.
It's repugnancy only, my lord, if the entire, allow. Kindly allow me, my lord, it would, then it's not a question of repugnance. It's complete lack of legislative competence. It would be, my lord, ultra vires. Then two, the entire bill violates some constitutional provision or some fundamental rights. Entire bill. If it is a part of it, he can say that I refer it to you and you
Delete it, amend it and
delete
come
it.
back.
If you still continue it, I can't withhold it, then it would be set aside by the Supreme Court if challenged, or the High Court if challenged. Even though the bill is within legislative competence and does not violate any fundamental rights, it is so manifestly arbitrary that it cannot be assented to. This is where, my lord, his statesmanly discretion would come, and I have given the examples. Please, my lord, minutely observe, because this is how, based upon your lordship's opinion, the polity of the country would govern. My lord, I am not arguing that present government is in center is a political party, state has a B political party. My lord, it can be reverse also. There are, my lord, political parties in the state which is, my lord, same party at the center. So we are not, my lord, on conferring discretion on the governor to Lord, kill the bill. That's not, my lord, the idea. It's really the interpretation of the word withhold. Political parties will keep on changing, my lord, in the respective.
We are not concerned with that. We are only concerned with
Yes.
provision as it is.
So therefore, my lord, my attempt is as a neutral student of law. This is how I perceive the constitution interpretation to be. Even, my lord, 98. In case the governor feels that either only a part of a bill is beyond the legislative competence or a part of the bill which violates some constitutional provision or abridges fundamental rights, he may return the bill so as to allow the legislature to cure the defect. The first proviso in case of a bill where the defect found by the governor is curable. When the governor feels that some part is curable, if you make a legislation for, say, defense of India, then it's not a curable bill. And I would not, as a governor, do that. I'll return it because thereafter I can't even withhold it. So that is where the term withhold at the first instance comes. Then 99. If the above interpretation is not given, it will result in disastrous consequences. Normally, it is presumed that all legislatures, in their collective wisdom, will not pass a bill which is manifestly unjust or arbitrary in its entirety. The power of withholding of the bill in the main provision, therefore, shall have to be used sparingly and only in extraordinary situations, when the very constitutional existence of the governor, who represents the democratic will of the nation manifested by the President of India, would be frustrated. Now see, my lord, examples I have given. These are hypothetical examples. For example, if the legislature were to pass following bills, the governor would be abdicating his duty if he does not withhold the bills, as he can neither assent to the bill nor reserve the bill for presidential reference. 1. If the legislature were to remove the concept of reservation itself in the entire state. 2. If the legislature, while removing the reservation based upon the parameters of Article 15 and 16, provides for reservation only based on religion, that only Hindus will get reservation, or Muslims only will get reservation. 15, 16, we are not bound. Third, one state legislature passing a bill preventing residents of other states from entering in that state. Lord, this is a state subject. But the governor may feel, and this has happened, my lord, I'm a slight deviation. This has happened not by way of a legislation during COVID. I'll not name the states, my lord, and everyone was doing in their own right. There was, my lord, one state whose hospitals were flooded with patients. So they were sending the patients to the neighboring states. And the neighboring states was fearing that we will also now feel shortage.
That matter was before me.
Your lordship, my lord, knows. So, my lord, barricades were created that one state people will not come in the other state. It was, my lord, a different fact situation. But suppose a bill is passed. I'm just giving, my lord, an example. The state legislature mandating use of only one particular language as a mandatory requirement for all residents of that state. Look, it is, my lord, a subject of the state list. It can do. The legislature excludes a particular class of people from exercising right to vote, either based on caste, sex, education, or any other ground. Earlier, my lord, only there was, my lord, a limited franchise. All citizens of India were not entitled to vote pre-constitution. A bill is passed by legislature giving complete immunity to the entire cabinet or all elected members from criminal prosecution. Well, then I cannot, as a governor, act on the aid and advice of for the very nature of things, my lords. A bill prohibiting central agencies like income tax authority, etc., from exercising their statutory powers within the geographical limits of that state. A bill providing for provisions which undermine the authority of high constitutional functionaries like the President, the Prime Minister, the judges of the Honorable Supreme Court, etc. Now, last, a bill which deals with jurisdiction of the Honorable Supreme Court of India itself. Lord, before I examine this, please see the second proviso to Article 200. Second proviso, my lord, please come back to page 150. This is the classic example, my lords. I'm not saying, my lord, elected people are responsible people. They act through their collective wisdom. But there can be one circumstance out of 1,000 where such an aberration happen. Lord, please see the second proviso to Article 200, my lords. Provided further that, your lordship gets, my lord, the governor shall not assent to. My lord, first proviso said he may, my lord, return it to the house. Governor shall not assent to, but shall reserve for the consideration of the president any bill which, in the opinion of the governor, would, if it became law, so derogate from the powers of the High Court as to endanger the position which the court is by the position of which that court is by this constitution designed to fill. Lord, suppose the act says something, and my lord, as per the true reading, there can be a local law with regard to the powers of the High Court that would be mandatorily subject to presidential assent. We are not concerned with that.
Would it not be read in that manner that wherever the constitution provided, as to in which cases the assent should not be granted, it has so specifically provided?
I'm on a different point. Forget, my lord, High Court. Suppose the legislature passes some act.
When a specific power has been granted to the governor, not to assent to in a particular circumstance, and can it not be read that that power is not granted in other matters?
No, it cannot grant, my lord. I'll come, my lord, on that textual interpretation also. Yes, but I'm just giving an example that suppose legislature passes a bill which directly deals with the powers of the Supreme Court. If it is High Court, I'm not on, my lord, whether I show that, my lord, only to show the absurdity of the potential bill. The lordships are trying to find a solution, my lord, find some conclusion. I'm still on, my lord, the problem. And after your lordship sees the problem, my lord, possibly your lordship may be in a better position to find out the solution. Suppose, my lord, in case of a High Court, the governor is bound to send it. In other cases, he may not. That's the discretion, because the main part says he may assent, he may withhold, he may refer. But proviso say he shall refer. So I am using it against, my lord, the proposition. Please see, my lord, just to immediately answer your lordship's question, the main provision says the governor shall be houses the legislature of the state. It shall be presented to the governor, shall declare that either he assents or he does this or he does this. So there are three options, but here there is no option. Here he has to reserve it for the president. And therefore, my lord, my submission that in the main part, there are three options available, gets 45. Lord, be that as it may, my lord, I'll come to that. Now, my lord, please see para 104. It is pertinent to note that nowhere in the substantive part of Article 200, the term as soon as possible has been used. So this is again on the time, but when we are on Article 200, as soon as possible is proviso when he returns the bill. It was there earlier with time limit in the pre-constitution regime, which was taken away. It is pertinent to note that nowhere in the subsequent part of Article 200, the term as soon as possible has been used, which means that the Constitution did not intend to put any sense of time limit during the exercise of first three options. Moreover, the governor under substantive part of Article 200 can simply sit or withhold assent to a bill if he believes that the bill is unconstitutional and beyond any remedial changes, in which case the bill shall fall through or lapse, as has been observed in several decisions of this honorable court, referred hereunder. The framers of the Constitution consciously avoided putting any timeline for exercise of powers either under Article 200 and 201, which is evident from the fact. Well, this is again on the question of timeline, but let me complete this, my lord, so that also assists your lordships. The time limit prescribed as shown in the history was consciously dropped in Article 111 and was replaced by the expression as soon as possible. And B, the very next Article 201 in its proviso stipulates the time limit for 6 months. Now, my lord, I have given dictionary meaning of the term withhold.
Time limit of 6 months is for the house, not for the.
Not for the governor or
for
the
governor or the president.
no. My lord,
That is for the house to reconsider.
I'm
and
grateful. So, my lord,
Suppose, it could be that if within 6 months, the house doesn't reconsider,
it lapses.
then the bill would happen.
Lapse. My lord, the point I'm making is not what happens to the bill. The point I'm trying to make is that whenever time is stipulated, it is provided for. You cannot read into it. It amounts to amendment of the Constitution. That's, my lord, a separate point, my lord, that I'll come to that. My lord, now what is the dictionary meaning of the term withhold? This is not considered by, my lord, the debate in Constituent Assembly debates, as your lordships had asked me. My lord, 106. My lord, as per the new international dictionary, withhold means to hold back, keep from action, to desist or refrain from granting, giving or allowing, keeping one possession or control. Refusing is also a part of the term withhold. Refrain from granting is also. Then return means to go back or come back again, to pass back to an earlier passover. Then, my lord, Black's Law Dictionary says withhold means to retain in one's possession that which belongs to or is claimed by another, and return means to bring, carry, or send back, the place in the custody, to place in the custody of, to restore, to re-deliver, to send back. Now, my lords, kindly come to 108. It is of utmost relevance to note that the constitutional requirement of expediency or a sense of urgency is incumbent upon the governor only when he decides to return the bill to the state legislature for reconsideration. This is evident from the expression, which I'll come to little later, my lords. My lord, please now come to my lord, directly, my lord, the judgment.
Which judgment, please?
I'll just, my lord, please come to page 164. Yeah, I'm sorry, my lord, no, not page 1. My lord, page 168. Then I'll take your lordships, my lord, to the potential acts which are, my lord, there are possible acts under the state list within the legislative competence of the state legislature, but cannot be assented to. There is no question of referring to the president, and returning is out of question, because even if I return it as a governor, and if it comes back, then I have no power of withholding. So I'll have to use that discretion on the first occasion. I have given the examples, I'll come to little later. Well, okay, kindly, my lord, have a look at page 166. Some examples, my lord. Where, what would the governor do? My lord, he is not just a postman. He represents the Union of India, appointed by the president. President is elected by the entire nation by way of an indirect election. And that is also a way of democratic expression, my lord. An individual who is not directly elected is no lesser than the individual who is indirectly elected. And again, the president acts as per aid and advice of Council of Ministers. And Council of Ministers are responsible to the entire parliament. This is the framework, my lord. This is the check and balance, my lord, which is there. Please come to page 166.
Yes.
My lord, Chief. 166. Well, these are the examples, my lord. A legislative session bill fixes only 2 sitting days per year. It is presented before the government. Lord, then a confidence motion bill requiring 2/3 supermajority to test the council's confidence, directly contrary to the constitution, etc., etc. Now, my lord, kindly come to page 168, the case law. My lord, before I read the case law, Lord, the 2-judge bench in Tamil Nadu, forget the facts, I repeatedly say, my lord, the 2-judge bench in Tamil Nadu relies upon a 3-judge bench in state of Punjab versus Union of India. State of Punjab takes the view that the word withhold will have to be read with first proviso, that you withhold and return, which in my submission is erroneous on textual interpretation and is in ignorance of several 5-judge judgments exactly on the point. And those judgments, my lord, now I place for your lordship's consideration. Page 1.
In a case law, generally,
We may start, my lord, at 2, my lord.
withholding you for 15 minutes.
No, my lord, on the contrary. That was, my lord, temporary. There is not withholding as, my lord, we understand.
That was withholding as Mr. Civil and the others understand.
Yes.
Probably is on your side today.
Always this side.
Always on.
On the wrong
He is
side.
always on the right side.
Wrong side.
Wrong.
We are always on the right side of law. My lord, we are always on your lordship's right side.
No, no. Last week, Mr. Kaur was on this side.
And we were on the same side,
You were-
opposing each other.
You were on the same side
Opposing.
till you change your view after the review.
Lordship's.
Which I am not really very more for a cup of coffee.
Yeah.
Great.
My lord, on this withholding, my lord, let me say something. My lord, I have one distinct advantage. And therefore, my lord, what I am saying is really on the interpretation of the constitution. Why I say I have a distinct advantage. I had been a law officer of a state where state government was of a different political dispensation, central government was of a separate political dispensation.
It's a reverse situation.
Today, it is a reverse situation. So
That time it was a reverse situation.
it was a reverse situation. my lord. Today also, it's today.
You would have been that side and you would have been this
Yeah,
side.
yes. So I know, my
You would
lord.
not have been on this side. You would have been somewhere else.
Lordships are right. So, my lord, functionally, how, my lord, it functions, my lord, I'm aware of it. So it's not, my lord, my attempt to protect the power of the governor anyhow. But, lord, I must, my lord, request your lordships that these are all plenary constitutional powers vested upon high constitutional functionaries. A possibility of misuse or abuse may perhaps not guide your lordship's interpretation. But for example,
The presumption is that the power in such high constitutional functionaries will be exercised bona fide.
correct, my lord. Time and again, your lordships, while sitting in the Supreme Court or on the division bench, have said that this was an abuse of writ jurisdiction. But then the problem is not with the writ jurisdiction. If we examine the contours of writ jurisdiction, it will have to be examined that it would be used for the purpose it is conferred upon the Constitution. Lord, now before I take your lordships to the judgments, may I request your lordships to read 20, 200 and 201, the way I like to read. And I am reading it as a student of law, the way it is to be construed. If there is a power of withhold, as I understand, Lord, let us not give any interpretation which kills the power. Whoever is the governor, whichever is the party in power in state, center, doesn't really matter. But kindly have a look at, my lord, even at the cost of repetition, my lord, 150, my lord. Please have a look at it, my lords. And then, my lord, I'll immediately come to the judgments. When page 150. When a bill has been passed by legislative assembly of the state or the council, it shall be presented to the governor and the governor shall declare. Either, my lord, would mean a choice. Either that he assents to the bill or, my lord, this is the second option, he withholds assent therefrom. So I'm withholding the assent of the bill. What is the meaning of withhold? I'll come to. Or that he reserves the bill for consideration of the president. He will have one of these three. Provided that the governor may, here it's not shall. Fourth option is given. As soon as possible after presentation of him to the bill for assent, return the bill if it is not a money bill together with a message requesting that the house or houses will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendment as he may recommend in this message. And when a bill is so returned, the house or houses shall reconsider the bill accordingly. And if the bill is passed again by the house or houses with or without amendment and presented to the governor for assent, please mark, the governor shall not withhold assent therefrom. Note how I give the meaning of the term withhold used in the proviso, that you will not kill it thereafter. Both words are used in the same provision and has the same meaning. Correct, my lord? Now, going it a little further, my lord, suppose he reserves it for the president. Then 201 comes into play. Please have a look, my lord. When a bill is reserved by the governor for the consideration of the president shall declare either that he assents to the bill or that he withholds assent therefrom. My lord, we take it that withhold means temporarily withholding. Then please see, my lord, the distinction in the proviso. Provided that where the bill is not a money bill, the president may direct the governor to so and so, so and so, so and so within 6 months of the date of receipt of such message, and if it is again passed by the house or the houses with or without amendment, it shall be presented again to the president. Because there is nothing, then it stands withheld. Because there is nothing above the president. That does not, it neither says, then the governor, president shall assent to the bill. So, my lord, both the provisions in the same document, namely the constitution, word withhold used at two places in Article 201, Lord, leads in my submission to only one conclusion, that withhold means in rarest of rare cases. But that, no, sorry, this cannot be done. And I have given instances. For example, and without, my lord, giving any real instances, central passes a law and some state legislature central means parliament passes the law, and some state passes a law based upon whatever considerations, that this law will not apply in my state, and the bill is presented before the governor. Can he assent? Answer is no. Can he refer it to the president? Answer is no, because it's palpably wrong. He can't return it because then he will be losing his right to withhold. Then, my lord, withhold is only in rarest of rare cases, in, my lord, exceptional circumstances, and therefore I said that where his existence as a constitutional functionary and his oath of office of defending the constitution requires him that I will have to withhold, because he is the only person apart from the president who takes oath of defending the constitution. Unless, my lord, this is read, the governor's office will merely become a post office. He can either assent or withhold it and send it back to the house. And if the house says no, nothing doing, we go ahead, then he cannot withhold, or as a postman, he will send it to the president. I don't think, my lord, the president's position is envisaged in the constitution as a postman. He has, my lord, a wisdom. And in real life, my lord, how things work out, I can tell your lordships, my lord. Lord, as a matter of fact, every matter doesn't come to your lordships. Lord, governors are also seasoned people. Political leaders are also seasoned people, irrespective of the party they represent. They have, Lord, years of political experience, public service, my lord, to their credit. What happens is, my lord, whenever a bill is presented, Lord, generally, the governor calls the chief minister and says that these two provisions are doubtful. And I would have very serious reservations. If it is repugnant, I'll have to refer it to the president. Sometimes, my lord, the chief minister also agrees that, all right, we also don't labor much on this. I can promise you, you return it to the house, we'll get it sorted out. And the matters are sorted out. Lord, every problem which may arise under the functioning of the constitution may not have an answer or a solution in legal proceedings. Lord, when the matter is referred, when the bill is referred to the President of India, there is a procedure stipulated under the office memorandum. Lord, it goes to the President's house. The President's house narrates what are the repugnancies, which provision is repugnant, how it is repugnant, whether it is repugnant. Thereafter, it is sent to the Ministry of Law as well as ministry, which is concerned ministry, which is called the nodal ministry. If it's education, it goes to education ministry. Agriculture, it goes to agricultural ministry. Then their feedback is received. That all right, there is some repugnancy, but both can coexist. It will, because why there is a requirement of presidential assent in some cases, that the bill of the state legislature should not be in conflict with the national policy formulated by the parliament. And therefore, that is the ground on which the nodal agency says that though there is a deviation in the state law, it is in fact not affecting the national policy. It is a state-specific provision, though repugnant to the central law. Then the president gives the assent. And otherwise, my lord, if in some cases, my lord, the president returns the bill, and if the bill is, my lord, again passed, it comes back to the president, and then it dies, it lapses. Because Article 201 proviso does not stipulate any my lord, consequence. My lord, if we were to accept, my lord, if your lordships were to accept the term withhold in the main provision of Article 200 to mean temporarily decide not to grant assent immediately. Look, kindly see, this is third angle. Lord, suppose the main part of 200 would have contemplated that withhold means kind of suspension of my powers, that I'll not withhold. And as state of Punjab judgment says, I will refer it to the House. Then the word used would have been, if the House returns, the president shall grant assent. But it says it will thereafter not withhold. Means your right to withhold ends if you do not exercise the first time. Otherwise, my lord, the only meaning, my lord, which we can give, if, my lord, the interpretation given by Tamil Nadu is right, that proviso last part says that if the bill is returned back by the House after reconsideration, he will grant assent, which is not there. He will not withhold it. That is, my lord, the answer. Now, please come to the judgments, my lord. Page 168, my lord. The first judgment is Kameshwar Singh. Start with the judgment, page 168. But, my lord, power being plenary in nature, it has to be left to his constitutional discretion, my lord, whether it is a case exceptional, not exceptional, my lord, that he will have to decide, my lord. That's the way, my lord, constitutional functionaries, powers, functions, responsibilities, limitations, they are, my lord, interpreted. That's my respect.
Exercise of power under the Constitution is never in a vacuum. When the laws were made originally, it was an ideal situation was contemplated. Take classic example, 10th schedule. When the law was made, everybody supported. The biggest authority who we all can rely on is the speaker. Speaker is the best authority, so therefore he should be the adjudicator. Now today, if we are asked to interpret 10th schedule, where a challenge is made to the powers exercised by the speaker, we would, with our experience, decide it in a different manner. Constitution is a Interpretation is a process. You take into account how the system is working, and it can't be frozen at a time when the article is made and what ideal situation was there at that point of
My
time.
lords are
So
absolute.
we will interpret it on the basis of how these constitutional functionaries are working and how the provisions have to be interpreted. But without reference to the political process which happens, and it will be rather difficult for a
About
constitutional
which the court
interpretation.
would have minimum knowledge, my lords.
So,
Possibly.
can the interpretation be static?
Ah,
Or
No,
it
no,
has
the
to be organic?
constitution is a living document, it's
It's a
interpreted.
living document, and like in that Telangana case, it was thought to be argued that in earlier constitution benches, no time limit was framed as to within how much time the honorable speaker should decide it. For the first time, in case of Justice Nariman decided. It was thought to be argued, but then
exactly.
I observed that when the bill was discussed for amending the constitution, Mr. Ashok Sen, who was the then law minister, he said that our experience is that in the courts, the matters are pending for so long that in many of the matters, the petitions become infructuous. So he gave an example of the Congress symbol. He said that though, I think it was initially well Jodi, I think, popular card, and then it was changed to
No, it was cow and calf. My lord, something.
what did it be? Because so he said that by the time we own the proceedings before the election commission, the proceedings had become infructuous, and we had already succeeded on a different symbol. And therefore, in order to ensure experiences in the matter, it was decided that the power should be given to the honorable speaker. But with the experience, so I observed in that at that time they did not anticipate when the earlier constitution bench decided the matter that the speakers would result the matters in a situation which ends in operation successful, patient dead.
That happens, my lord, in court also, but I'll come to that. There is one judgment, my lord, that therefore I say that inability for good reasons, bad reasons of one organ to do what is expected would not empower another organ to take over. My lord, I'll come to that, my lord, because
We believe in separation of powers, but then
no, Mr. Sen was right, and he could say that because he was in parliament with, my lord, privileges attached to it, my lord. But your lordships would also be, my lord, aware, and your lordships are aware, that the speaker, under the tension,
so that we are, I have already observed that we are issuing
Yeah, Lord,
unanimous because the speaker has been held to be a tribunal amenable to the jurisdiction
Therefore-
of this court and Article
therefore,
226 and
that's the
227.
point, my lord, he is a
And-
tribunal.
And he does not enjoy the constitutional immunity as a speaker because the proceedings before the speaker are not the
He's a tribunal, it's
are
not within
not
the
the
house.
proceedings before the legislative council, and so I have observed that with two riders, why were we issuing a mandamus to the
No, certainly.
honorable
My
speaker?
lord, your lordships fixed the time limit, and rightly, in case of 10th schedule, because speaker, right from Quixote Holohon, he is held to be a tribunal. He is not exercising, my lord, any
Tribunal,
plenary.
I'm amenable to the jurisdiction of High Court under 226, 227, and this court under
Absolutely.
136.
So, my lord, let me come to, my lord, page 168. I'll come to that judgment, my lord. That is one of the judgments relied upon by the other side. And therefore, I'm going to say that. Lord, as a matter of fact, and it would be interesting, I'll go in detail when I reach that stage. Lord, the parliament, my lord, amended the law that because judiciary is unable to do within a particular time limit.
Judiciary as well as the election commission.
No, not in
No,
that matter.
No,
Not in that, some other matter.
no, in Mr. Ashok Sen specifically says in his judgment that the proceedings before the judiciary and the election commission take so long.
No, I'm on a different judgment, but I'll read that.
Huh?
Symbol matter, my lords.
For election symbol.
I never want to touch on those
I
subjects.
think it was a cow and calf, and then I think they won the elections on Punjab.
Yes. Yes. The cow was, my lord, quite auspicious for them.
That's right.
We will not go into those issues.
Let's not.
We'll restrict ourselves to the.
Comment, brother.
No, and in any case, I am asking a wrong question, my lord, now. My lord, page 168. Please have a look, my lord, this. 168. My lord, the judgment. This is a 5-judgment judgment. State of Bihar versus Kameshwar Singh. My lord, for two purposes I am relying upon. A, the governor is a part of the legislature and whatever function he exercises is quasi-legislative. The power of assent is quasi-legislative. And there are judgments on that, my lord, point. My lord, please come to, my lord, page 169. Which, my lord, my learned friend is right. It's legislative. Lord, 198, I have just highlighted. I am not right now saying this, my lord. I'll come to a separately. The legislature of Madhya Pradesh consists of governor and the legislative assembly, but relevant is 235 at page 170.
Where you read this, sorry?
I'm sorry, my lord. Page 168, the judgment starts. It's State of Bihar versus Kameshwar Singh.
Para 198.
Okay, you quoted in the para. Okay.
Yes, but it's quoted, my lord. It is
For a judge.
Constitution bench.
Highlighted.
It's a 5-judge bench judgment. My lord, kindly see at 169. My lord, I'm at the foot. My lord, please come to page 168, para 20. Mr. Somaya's argument. Your lordship gets me? My lords get me.
Yes.
Mr. Somaya's argument based on clause 3 of Article 31.
You are
which
at page,
left-
page,
Page
168 bottom.
168
bottom.
at the foot, my lord. State of Bihar versus Kameshwar Singh, para 20. Mr. Somaya's argument based on clause 3 of Article 31, to which reference has been made earlier, is equally untenable. It is true that the legislature of the state includes the governor and that a bill passed by such legislature cannot become a law until, please mark, until it receives the governor's assent. Article 200, however, contemplates one of the 3 courses being adopted by the governor when a bill is presented to him after it is passed by the House or Houses of Legislature. 1, to give his assent, or to withhold assent, or 3, to reserve the bill for consideration of the President. Correct, my lords? The first proviso to that article deals with a situation where the governor is bound to give his assent and has no relevance here. The second proviso makes reservation compulsory, where the bill would, if it became law, derogate from the powers of the High Court, but such reservation, it is important to note, should be made without the governor himself having assent to the bill, giving assent to the bill. It is significant that the article does not contemplate the governor giving his assent, and thereafter, when the bill has become a full-fledged law, reserving it for the consideration of the President. Indeed, the governor is prohibited from giving his assent where such reservation by him is made compulsory. The Constitution would thus seem to contemplate only bills passed by the House, etc. Please come to 235 at page 170. Great.
How do you, the first proviso to that article deals with the situation where the governor is bound to give his assent.
If it returns, if it is returned, that's what they say. Obviously, he cannot withhold, then he has to.
Yes.
My lord, he can withhold, or my lord, he can give assent, or he can even still refer. He can still refer. He may give an opportunity to the legislature.
So according to that is his choice. Either he can withhold
No, I'm
or send it to the, or return it to the legislative house.
No, my lord, I'm sorry, my lord. I'll again, my lord, make myself clear. He has 3 options in the main proviso. He can grant assent straight away. He can withhold, which according to me, the bill lapses or bill falls through, as Supreme Court says. And third option, refer it to the president. Fourth option, other than these three, is when he feels that there is some repugnancy somewhere or there is some tweaking required somewhere, then with his message, he will send it, he will return it to the House with a request to reconsider it. When the House reconsiders it, then the embargo is he cannot withhold, but he can still say that, all right, you have not considered my suggestion, you have not removed the repugnancy or whatever difficulty I have suggested. I now refer the matter to the president for his assent. That is not prohibited. Correct, Madam? Now please come to 235. Great stress is laid on the words law and the legislature of a state. It is stated that the clause postulates a law made by the legislature of a state. Reference is then made to Article 168, which provides that for every state there shall be a legislature which shall consist of the governor, and so far as Madhya Pradesh is concerned, of one house, that is Legislative Assembly. The argument is that Article 31(3) requires that a law must be reserved for the consideration of the president. If a bill passed by the assembly is reserved by the governor for consideration of the president without giving his own assent thereto, it cannot be said that a law is reserved for consideration of the president, for up to that state the bill remains a bill and has not been passed into law. Therefore, it is urged that after a bill is passed by the state assembly, the governor must assent to it so that the bill became law, and then that law to have effect must be reserved for consideration of the president. This admittedly not having been done, the provisions of Article 31(3) cannot be said to have been complied with, and therefore the act cannot have any effect at all. I am unable to accept this line of reasoning. For one thing, it assumes that a bill passed by the state assembly can become a law only by the assent of the governor. That is not so. Now please see. The procedure to be followed after a bill is passed by the state assembly is laid down in Article 200. Under that article, the governor can do one of three things, namely, he may declare that he assents to it, in which case the bill becomes a law, or he may declare that he withholds assent therefrom, in which case the bill falls through.
Falls through unless the procedure indicates.
yes.
Is followed.
Falls through. So, if he does not choose, my lord, the option of proviso, the bill falls through. So, unless means that's the option. Either I withhold or I revert, I return the bill. Otherwise, it has no meaning. Falls through has no meaning. Therefore, unless is an exception, that if he withholds at the first instance, it falls through. Unless he resorts to the proviso, unless the procedure indicated in the proviso is followed, or he may declare that he reserves the bill for the consideration of the parliament, in which case the president will adopt the procedure laid down in Article 201. Under that article, the president shall declare either that he assents to the bill, in which case the bill will become law, or that he withholds assent therefrom, in which case the bill falls through, unless the procedure indicated in the proviso is followed. So, falls through has only one meaning.
Why is it combined with unless? The proviso.
Because it's an option given.
That's a completely separate, disjuncted and independent of falling through according to your
Correct,
reading.
my lords.
According
Correct.
to your reading, proviso is completely different to declaration.
Fourth option.
The fourth option.
So, my lord, what it says is, I'll put it, my lord, I rephrase myself. My lord, unless he exercises the fourth option,
Then there is no declaration of withholding.
that's
He cannot, the governor
But
cannot,
that's where, my
on the
lord-
one hand, declare that he is withholding,
that's exactly what I'm saying, my lord.
same time exercise
Correct.
option 4.
Correct, my lord. Therefore, I'm saying that he has to assent, withhold, or reserve, unless he chooses the fourth option. Otherwise, one of the three options are complete in themselves. So therefore, my lord, my submission is that the proviso is an exception to first, second and third in the main part. He may not grant assent, he can return it. He may not withhold, he may return it. He may not reserve it for precedent, he may return it. But after returning, if it is passed, one option is taken away, he can either assent or.
Is it your argument, Mr. Solicitor, that if the governor exercises option number 2, that means withhold? If he exercise, let us say rather otherwise, if the governor decides to exercise the option 1, 3 or 4, then he cannot fall back on option number 2.
Yes,
Withhold.
yes.
But if he exercises option number 2 as the option number 1,
First
he
option.
still have the prerogative to exercise option number 4.
No, he cannot thereafter.
According to him,
Unless,
according to him, if the governor chooses to exercise option 2, withhold, the bill falls through.
he'll fall through, but then
Unless is the word used in the judgment, it's not in the
Prejudice.
article.
unless the procedure indicated in the proviso is followed.
Meaning thereby,
Beforehand.
meaning thereby, he can assent or follow the proviso. He can withhold or follow the proviso. He can reserve it for the precedent or follow the proviso. But if he withholds, there is no question of following the proviso. That is why it says, the proviso says, then you cannot withhold. Because then you have you have abandoned your right of withholding at the.
So there are in two ways you would look at the second option of withholding. One is standalone withholding, that when at the commencement, governor says that I withhold, standalone, it will come to an end. There is no further adjudication.
That's my submission.
Second situation is where he seeks to withhold, but he will first resort to the proviso and then send it back. And after it comes back, he can't withhold.
He cannot.
That's what you're saying.
Yes. That out of 3, he says,
You're saying.
I'll not, yes. Out of
But
3,
your contention basically is that the standalone withholding and straight away tell him that I am not going to grant you any further will disentitle the governor from invoking the proviso second time.
I'm grateful.
But that takes you to the larger question of course, we will test this also.
Well, that's why we have.
Therefore, the question of judicial review becomes far more important. There your stand is there is no judicial review.
There is
That is
no,
the scary
I'm
part
not
of
saying
it.
there
That's
is no
why,
judicial.
that's why,
Difficult part.
I'm sorry. I am saying it's not justiciable, and Supreme Court has said.
Same thing.
that's why
Supreme Court.
expressions,
Can't be
two
replaced.
expressions shall declare acquires lot of eminence and importance, because shall declare means that it's not a simple empty declaration. If you want to withhold, then that declaration must also assign brief reasons of withholding. Otherwise,
that
how to exercise the power of judicial review?
You have a.
My lord, your lordship, sir, my lord, I am yet to argue on judicial review and justiciability. My lord, there are several powers under the constitution where we are not, my lord, for example, president also, my lord.
Well, like, secondly, in the context you
Only
are saying that if the second option is exercise withholding, that he withhold, and then he can't exercise the other options.
Yes.
If you are talking of,
Other option of returning, yes.
Mr. Mehta,
if we are talking of the wider powers of the governor, then why this curtailment? Today, he decides to withhold it
Yes.
because he feels that this bill is completely extra constitutional. This is so and so. Then later on an advice, he feels that if with certain amendments, certain modifications, this bill can also pass the muster of the
Then he can,
constitutional.
he can,
Therefore, what prevents him to exercise option number 4 to return it with that message? And let us, how to read this curtailment of power under 2
in a fact situation, my lord, suppose he withholds,
Absolutely right. Tell you, because that's the political process, how it occurs.
that's exactly.
Not like a.
It's quite possible that the chief minister may go and say that, please don't withhold.
That the way political process occurs is not adjudicatory. where a decision is taken, it's nothing like a decision taken. Even assuming that the governor says that I withhold, again, political process can again knock on his door. He can still open it and say, okay, all right, I see a reason, then I'll send it back to you, reconsider, and then send it back. But to say that first time when he says I withhold, matter comes to an end, that can't be like that. It can't, because it's counterproductive to the powers of the governor, counterproductive to the legislative process also. So it has to be in a situation where it should be open-ended, that first he might say no. We see the point in what you are saying. If it is grossly a case falling directly under list one, he could say no, but he could also say, please modify it, rectify it.
Suppose the entire, suppose
राज्यसभा के 10 सदस्यों को मिलकर बनने वाली संयुक्त समिति को सौंपा जाए। संयुक्त समिति की बैठक
बोलेंगे ये देश को संस्थान को पहले 5 वर्षों के लिए संचालित करने के लिए भारत सरकार ने 2,555 करोड़ रुपए की राशि आवंटन की गई है। वो सबसे बड़ी बात है कि
2020, keeping the sectors.
माननीय सदस्य, ये संसद के अंदर आपका तरीका ठीक नहीं है। आप संसद की मर्यादाओं को तोड़ रहे हैं। ये मैं आपको मौका दे रहा हूं, इसका मतलब ये तरीका नहीं है आप संसद की मर्यादाओं को तोड़े। नो, आप इस तरीके की हरकत करते हैं। आपको इसलिए चुनकर भेजा संसद में। प्लीज बैठिए। आप ये तरीका आपका ठीक नहीं है। देश की जनता देख रही है। संसद में मर्यादा रखो। आपको विरोध का तरीका, विरोध करो आप, कोई दिक्कत नहीं विरोध का, लेकिन विरोध का ये तरीका क्या उचित है? क्या कोई नैतिकता वाला बिल आ रहा है? राजनीति में नैतिकता, स्वच्छता बननी चाहिए। उसके बाद ये स्थिति है आपकी। ये तरीका ठीक नहीं है। मैं आपको बता रहा हूं कि इस तरीके को सुधार लो आप। नो, इधर आइए। ये तरीका है आपका। आप संसद सदस्य हो, मर्यादा की पालन करो। कभी कोई ने मर्यादा ऐसी खराब नहीं की। आप ऐसे मत करिए मर्यादा खराब। नो। अब मैं आइटम नंबर 20 ले रहा हूं। प्रश्न ये है कि विधेयक को पुनर्स्थापित करने की अनुमति प्रदान की जाए। जो सदस्य इसके पक्ष में हाँ गए, जो सदस्य विरोध में ना गए, मेरे विचार में निर्णय हाँ वालों के पक्ष में, हाँ वालों के पक्ष अनुमति प्रदान किए थे। माननीय मंत्री जी, माननीय अध्यक्ष जी, मैं विधेयक को पुनर्स्थापित करता हूं। आइटम नंबर 21। प्रश्न ये है कि विधेयक को पुनर्स्थापित करने की अनुमति प्रदान की जाए। जो सदस्य इसके पक्ष में हाँ गए, जो सदस्य विरोध में ना गए, मेरे विचार में निर्णय हाँ वालों के पक्ष में, हाँ वालों के पक्ष में अनुमति प्रदान की जाती है। माननीय मंत्री जी, अब विधेयक को पुनर्स्थापित करें।
अध्यक्ष जी, मैं विधेयक को पुनर्स्थापित करता हूं।
आइटम नंबर 22। प्रश्न ये है कि विधेयक को पुनर्स्थापित करने की अनुमति प्रदान की जाए। जो सदस्य इसके पक्ष में हाँ गए, जो सदस्य विरोध में ना गए, मेरे विचार में निर्णय हाँ वालों के पक्ष में, हाँ वालों के पक्ष में अनुमति प्रदान की जाती है। माननीय मंत्री महोदय,
माननीय अध्यक्ष जी, विधेयक को पुनर्स्थापित किया जाए।
आइटम नंबर 24। माननीय गृह मंत्री जी।
माननीय अध्यक्ष जी, मैं प्रस्ताव करता हूं कि भारत के संविधान का संशोधन करने वाला विधेयक, संघ राज्य क्षेत्र शासन अधिनियम 1963 का संशोधन करने वाला विधेयक
तथा जम्मू कश्मीर पुनर्गठन अधिनियम 2019 का संशोधन करने वाले विधेयकों को माननीय अध्यक्ष जी द्वारा नाम निर्दिष्ट किए जाने वाले इस सभा के 21 सदस्य और माननीय उपसभापति द्वारा नाम निर्दिष्ट किए जाने वाले राज्यसभा के 10 सदस्यों को मिलकर बनने वाली संयुक्त समिति को सौंपा जाए। संयुक्त समिति की बैठक की गणपूर्ति और बाकी सारे नियम लोकसभा के नियमों के अनुसार होंगे और अगले सदन के पहले दिन तक ये संयुक्त समिति रिपोर्ट प्रस्ताव करे, ऐसा मेरी दरखास्त है।
प्रश्न है कि माननीय गृह मंत्री द्वारा प्रस्तुत प्रस्ताव स्वीकृत किया जाए। जो सदस्य के पक्ष में हाँ गए, जो सदस्य विरोध में ना गए, नो हाँ तो किया जा सकता है, लेकिन तरीका को सुधार लो आप। मैं आपको भारत की संसद की मर्यादा बनाने के लिए बार बार आग्रह करता हूं। मेरे विचार में निर्णय हाँ वालों के पक्ष में प्रस्ताव स्वीकृत हुआ। माननीय सदस्यगण, मैं आपसे आग्रह करता हूं कि संसद की मर्यादा गरिमा को मत गिरने दो। देश आपको देख रहा है। कुछ विधेयक राजनीति में नैतिकता के लिए आते हैं। नैतिकता और आचरण हमारे जीवन में होना चाहिए। सदन की कार्रवाई आज 5 बजे तक के लिए स्थगित की जाती है। आइटम नंबर 20, 21 और 22।
महोदय, मैं प्रस्ताव करता हूं कि भारत के संविधान का संशोधन करने वाले विधेयक को पुनर्स्थापित करने की अनुमति दी जाए। महोदय, मैं प्रस्ताव करता हूं कि जम्मू कश्मीर पुनर्गठन अधिनियम 2019 का संशोधन करने वाले विधेयक को पुनर्स्थापित करने की अनुमति दी जाए। महोदय, मैं प्रस्ताव करता हूं कि संघ राज्य क्षेत्र शासन अधिनियम 1963 का संशोधन करने वाले विधेयक को पुनर्स्थापित करने की मंजूरी दी जाए।
कर दिया। श्री असाउद्दीन ओवैसी जी।
Sir, I stand to oppose the introduction of J&K Reorganization Amendment Bill 2025, Union Territories Amendment Bill 2025, and the Constitution 130 Amendment Bill 2025, sir. Sir, this violates principle of separation of powers, due process, undermines the right of the people to elect a government. Sir, it gives executive agencies a free run to become judge and jury executioner based on flimsy allegations, suspicions, sir. Sir, only when an offence is proved beyond reasonable doubt, then only you can leave the post and the membership. But here a mere accusation, allegation, the punishment of losing one ministerial post will follow. Sir, Parliament democracy's chief ministers and ministers can only be removed through true means. First, executive prime minister can recommend their removal if the second council of ministers lose confidence of the legislature. Now this bill would empower the unelected executive bureaucracy to play the role of legislature. Sir, it undermines representative parliament democracy. This amendment would leave the minister and CM at the mercy of executive agencies. The severity of the amendment is not only in the fact that one loses their position if they are arrested, but even if they are detained. Detention and administrative action doesn't require offence to be made. Sir, the chief minister will not be able to accountable people. I want to know from the Honourable Home Minister, as he read Article 74(1), which says that the Council of Ministers headed by the Prime Minister to aid and advise the President who shall, in exercise of his function, act in accordance with such advice. Now, this bill clearly violates 74(1). Sir, this is the 1933 Gestapo when Gestapo was found in Germany. This government is hell-bent on creating a police state. This will be a death knell and leash an elected government, sir. Indian Constitution is being amended to turn this country into a police state. BNS 152, the Home Minister promised in this House that sedition would not be used. Section 316, Section 9 of BNS, PMLA Section 4, all these can be used to destabilize an elected government, sir. That is why I oppose the introduction of all these three bills. This is nothing but creating a Gestapo to ensure that our democracy does not survive. And may I tell the Honorable Home Minister, despite his promise on BNS 152, 152 has been used against a senior journalist, Siddharth Vardhan, Assam also. That is why I oppose this introduction of three bills, sir. Thank you.
Tiwari.
Speaker, sir, I rise to oppose the introduction of these three bills under Rule 70(1) of the Rules of Procedure and Conduct of Business in the Lok Sabha. This bill is squarely destructive of the basic structure of the Constitution. अध्यक्ष महोदय, भारत का संविधान का जो मूलभूत ढांचा है वो ये कहता है कि कानून का राज होना चाहिए. There should be rule of law. और उस rule of law, कानून के राज की बुनियाद है कि आप बेगुनाह हैं जब तक आपका गुनाह साबित नहीं किया जाता. You are innocent until proven guilty. This bill stands that fundamental maxim of jurisprudence on its head. It makes an investigating officer the boss of the Prime Minister of India. The second ground on which I oppose this bill, it violates Article 21, the due process clause. FIR, arrest, charge sheet, and even framing of charge does not in any manner substantiate guilt. In fact, you plead not guilty only after charges are framed against you. This bill turns the fundamental jurisprudence of Article 21 on its head. Number three, it distorts parliamentary democracy, which is again basic structure, by displacing will of the people through mere custody, bereft of judicial determination. अध्यक्ष जी, ये बहुत ही संवेदनशील विधेयक है. मेरे दो बिंदु और हैं, मुझे कृपया. चौथा, on the fourth ground is it opens.
प्लीज, माननीय सदस्य, आप नियम 72 के तहत विरोध कर रहे हैं.
अध्यक्ष जी, बिल्कुल.
जब कभी बिल आपका सदन में आए, जब आप डिटेल में चर्चा करना.
अध्यक्ष जी,
अभी नियम 72 के विरोध के बाद सारांश बोलने की परमिशन दिए.
जो रूल 72 है वो दो चीज कहता है, एक लेजिस्लेटिव कॉम्पिटेंस, एक जनरल ऑपोजिशन ऑफ द बिल, जिसकी स्वीकृति आप दे सकते हैं. और क्योंकि ये इतना संवेदनशील विधेयक है, मैं आपसे ये विनती करता हूं इसके ऊपर पूरी चर्चा कराई जाए. मेरे सिर्फ दो बिंदु और हैं. दिस बिल, मिस्टर स्पीकर, से
एक मिनट. आपने कानूनन बात की, तो कानून ये भी है कि 72 इसके बाद भी अलाउ करता हूं, लेकिन संक्षिप्त में.
बिल्कुल संक्षिप्त में अध्यक्ष जी.
आपको डिटेल में चर्चा.
मेरे सिर्फ दो बिंदु और हैं. This bill opens the door for political misuse by instrumentalities of the state whose arbitrary conduct has been repeatedly frowned upon by the Supreme Court. And finally, it throws all existing constitutional safeguards to the winds. Collective responsibility, judicial review, no confidence motion, and disqualification and conviction. And this makes this amendment excessive, unnecessary, and unconstitutional. इसलिए मैं इन तीनों विधेयकों का पुरजोर विरोध करता हूं और गृह मंत्री से मैं ये आग्रह करना चाहता हूं कि ये तीनों विधेयकों को वापस लिया जाए.
एन.के. प्रेमचंदन.
Speaker, sir, I strongly oppose the bill, 130th Constitutional Amendment Bill, as well as the other two bills I strongly oppose on 4 grounds. So the first ground is the bills are to be introduced according to the rules and procedure of the House. The bill is not circulated among the members. Yesterday after 1 o'clock we have received the copy of the bill, and I would like to know from the Honorable Minister, what is the undue haste and urgency in bringing such a constitutional amendment bill? What is the emergent need of having such a bill? That means the introduction of the bill itself is lacking bona fides. The bill is lacking bona fides. That is why I would like to say that this is with a mala fide intention to destabilize the opposition rule parliamentary number one.
एक मिनट माननीय अध्यक्ष जी, प्रेमचंद्रन जी कह रहे हैं कि जल्दबाजी में लाया गया। इसका सवाल इसलिए नहीं उठता कि मैं इस बिल को संयुक्त समिति को सौंपने की दरखास्त करने वाला हूं। इस पर संयुक्त समिति जो राज्यसभा और लोकसभा पक्ष और विपक्ष सभी सांसदों की बनेगी, जो इस पर विचार करेगी और आपके सामने लेकर आएगी।
Sir, I do agree with the Honorable Minister, but at the same time, the members are having the right to oppose the bill at the time of introduction. This is the legitimate constitutional right of each and every member to oppose the bill at the time of introduction of the bill. That is being contained. That is the problem which I am trying to say. And the second one is that is disqualification.
श्री वेणुगोपाल
Sir, I rise to oppose the introduction of the Constitution Amendment Bill 25, the government of Union Territory. Sir, this bill is to sabotage the federal system of this country. This bill is to sabotage the basic principle of the constitution of this country. Sir, BJP people are telling this bill is to bring morality in politics. Can I ask a question to the Honorable Home Minister? When he was the Home Minister of Gujarat, he had been arrested, sir. Whether he took the morality of that point of time?
ये विषय नहीं है,
Morality of that point of time?
गृह मंत्री जी,
अब मुझे सुनो जरा, मुझे सुनो,
गृह मंत्री जी,
मुझे सुनो ना, पहले बैठ जाओ।
हाँ, गृह मंत्री जी।
माननीय अध्यक्ष जी, मैं रिकॉर्ड क्लियर करना चाहता हूं। मुझ पर झूठे आरोप लगाए तब अरेस्ट होने के पहले मैंने नैतिकता के मूल्यों का हवाला देकर इस्तीफा भी दिया और जब तक मैं कोर्ट से निर्देश नहीं हुआ, कोई संविधान पद मैंने स्वीकार नहीं किया। ये क्या सिखाते हैं नैतिकता में? मैं तो इस्तीफा देकर गया था और मैं तो चाहता हूं कि ये नैतिकता के मूल्य बढ़े। हम ऐसे निर्लज्ज नहीं हो सकते कि हम पर आरोप लगे और हम संवैधानिक पद पर रहें। अरेस्ट के पहले मैंने इस्तीफा दिया है।
माननीय सदस्य, आप बिल पर बोलिए। आप 72 के नियम के तहत बोलिए।
सर, दिस नियम से आपका डायरेक्शन है। 19
आप 72 नियम के तहत बोलिए।
सर, लाइक नहीं है सर।
नियम के तहत बोला आप 72।
सर, दिस आपका डायरेक्शन है 19A, 19B।
हाँ है।
Chapter on call भी है।
हाँ।
Very clearly telling at least 1 week notice is needed for introducing a bill. Sir, I am telling that this bill is to target the opposition ruling government. This bill is to threaten the people like Nitish Kumar and Chandrababu Naidu. This bill is to blackmail. Sir, out of sir, my time one.
आप माननीय सदस्य, आप 9 चलिए। धर्मेंद्र प्रधान जी बोलना चाहते हैं?
प्रधान नहीं यादव।
आपके मेंबरों को बिठाओ।
धन्यवाद अध्यक्ष जी। मैं ये जो तीनों के तीनों विधेयक आए हैं, संविधान का 130वां संशोधन विधेयक 2025,
1 मिनट,
संघ राज्य विधेयक,
देश देख रहा है आपको,
संघ राज्य शासन विधेयक 2025, जम्मू कश्मीर पुनर्गठन विधेयक 2025, इन तीनों का माननीय अध्यक्ष जी अपनी पार्टी, अपने नेता आदरणीय अखिलेश जी की ओर से पुरजोर विरोध करता हूं। और विरोध इसलिए करता हूं माननीय गृह मंत्री जी, बहुत नैतिकता की बातें कर रहे हैं आप। आपने भाषण दिए थे चक्की पीसिंग महाराष्ट्र में, जिनको लेके डिप्टी सीएम बना के घूम रहे हैं आप। इसलिए अध्यक्ष जी, मैं इस मौके पर कहता हूं, ये बिल संविधान विरोधी, मूल अधिकार विरोधी, न्याय विरोधी।
अध्यक्ष जी, मैं प्रस्ताव करता हूं कि भारत के संविधान का संशोधन करने वाले विधेयक, संघ राज्य क्षेत्र शासन अधिनियम 1963 का संशोधन करने वाले विधेयक और 2019 का और संशोधन करने वाले विधेयक को माननीय अध्यक्ष जी द्वारा नाम निर्दिष्ट किए जाने वाले इस सभा के 21 सदस्य और उपसभापति द्वारा नाम निर्दिष्ट करने वाले 10 सदस्यों के मिलकर बनने वाले सभाओं की संयुक्त सौंपा जाए।
आइटम नंबर 20, 21 और 22 आइटम
स्थापित किया जाए।
आइटम नंबर 24 माननीय गृह मंत्री जी।
माननीय अध्यक्ष जी, मैं प्रस्ताव करता हूं कि भारत के संविधान का संशोधन करने वाला विधेयक, संघ राज्य क्षेत्र शासन अधिनियम 1963 का संशोधन करने वाला विधेयक तथा जम्मू कश्मीर पुनर्गठन अधिनियम 2019 का संशोधन करने वाले विधेयकों को माननीय अध्यक्ष जी द्वारा नाम निर्दिष्ट किए जाने वाले इस सभा के 21 सदस्य और माननीय उपसभा